Good afternoon. We have over 6.5 hours of argument time. So those of you who are familiar with our practice know the spiel. Please ask for the time you need, not the time you want, as we have read the briefs and the record and are familiar with your cases. And if you don't, I will. People versus Arturo Medina. Five and 1 and 5. Rivera versus Shipri Realty Corp. And you're here for respondent. Okay, I'll give you 3 minutes since you have no one to argue against. B Heaven is submitted. Joby versus Chelsea Hotel. You want response time? Yes. How much? Okay, 6 and 2 and 6. People versus Javon Campanioni. Okay. 5 and 2 and 6. Okay. People versus Burns is submitted. Murphy versus Goldman Sachs. Submitted. Wu versus Torres.
5+2, Your Honor. Respond in 5 minutes, please.
5 and 2 and 5. Neubauer versus City of New York. 5 and 2 and 6. Felicia versus Titina is submitted. Vendome versus Oldenburg. Respondent? Okay. 4 and 1 and 4. People versus Joseph Elliott. 5 and 1 and 5. People versus Eugene Graham. 5 and 2 and 5. Shuttle Cloud Corp versus New York State Department of Taxation. 5. I'm sorry, go ahead. Okay, who are you here for? Okay. And who are you here for? Okay. All right. So 5 and 1, 4 and 4. Lou versus Ruiz. 5 and 2 and 6. People versus Jimenez Gomez.
Can you tell him 7, Your Honor? Your Honor, people are apologizing to the court. ADA Tori Wu is planning on arguing, but she got sick and
Okay. So since they're submitting 5 minutes? 5 minutes? If we have questions, we can keep it going, okay? Ajoku versus New York State Office of Temporary and Disability Assistance. Okay. 6 and 2 and 6. People versus Whitfield. 4 and 1 and 4. People versus Reyes. 4 and 1 and 4. People versus Wadley is submitted. Orozco versus City of New York is submitted. And Thomas versus Karen's Body Beautiful is submitted. First case to be argued, People versus Arturo Medina. You may proceed.
Good afternoon. May it please the court. My name is Justin Bonus. On behalf of Mr. Medina, I really can't say it any more simply than this. I'd like to address first the leave application that the court granted. And as somebody who does a lot of post-conviction litigation, this is an eyewitness case. This isn't an alibi case. This is an eyewitness case. And Mr. Medina has presented 4 eyewitnesses. One of them testified at trial, there's no doubt about that, but 4 of them. And the last motion that Mr. Medina submitted, there was a submission in 2018 that was denied by the trial court summarily, and I disagree with that decision, but there was another motion submitted with an additional affidavit from Luis Rodriguez, a person who, and the court should understand this was a card game, an illegal poker game where no one really knew people's real names. These are nicknames, and the newest—
That's not so unusual in some neighborhoods, counsel.
Excuse me, Your Honor?
That is not so unusual in some neighborhoods.
Understood. Yeah.
Flacco, Tony, you don't know their last names, you just know their first names or their nicknames.
Yes, and well, it does explain why maybe Mr. Rodriguez wasn't found at trial.
Well,
Okay.
what was the due diligence that was exercised to try to find Mr. Rodriguez?
Excuse me, Your Honor?
What was the due diligence that was exercised to try to find Mr. Rodriguez?
Well, the due diligence here, would have to come from Mr. Medina, and not knowing somebody's name, having to talk to other witnesses. And I think really the due diligence question has to be answered at a hearing. All right, that's where the due diligence question gets answered. If you look at People v. Scott, which is from the 4th Department, it talks about when you have evidence of a witness, specifically in a case like this, and People v. Scott was an alibi case, but this was, again, these are eyewitnesses. Luis Rodriguez, Martin Padilla, who was sitting in the hallway ready to testify. These are eyewitnesses. And these were independent witnesses. These were witnesses that were known by the victims, and these were witnesses that were known by Mr. Ventura, who's the co-defendant. And we have to remember here, this was really an acting in concert case. This was a robbery that where an injury happened to Mr. Veras, and Mr. Veras accused Mr. Ventura and Mr. Medina, my client, of robbing him and Ms. Remigio. So, we have to remember these are eyewitnesses. And the due diligence here, I think, can only be vetted out at a hearing. I mean, Martin Padilla, we don't really know the reason for why Martin Padilla wasn't called in the hallway. That wasn't addressed even by the trial court in the first decision in 2018. The trial court in 2000, and I'd love to address that decision. The trial court assesses credibility, okay? Literally assesses credibility in a summary denial. And that's not right.
Counsel, are you saying that these witnesses that weren't called at trial, they were newly discovered evidence? Is that what your argument is?
Well, I'm arguing that they are either newly discovered evidence or they're the product
Counsel,
of
how about
defense.
Mr. Almonte? Wasn't he known to the defendant?
Excuse me, Your Honor, I didn't hear your question.
Mr. Almonte, wasn't he known to the defendant?
It's either these witnesses are either newly discovered evidence or it's the product of ineffective assistance of counsel. And so that's the question that needs to be flushed out at a hearing. Somebody as important as
Didn't he
Mr.
testify that
Rodriguez.
didn't he indicate that he didn't see what went on behind him, but he heard sound and believed that the victim got hit behind him, never saw the gun? Wasn't this person known to the defendant?
I couldn't really.
Sorry. Wasn't Mr. Almonte one of the 4 witnesses? Wasn't he known to the defendant from day
Are you talking about Mr. Rodriguez, who would be we? That's what everyone knew him as. Everybody was known here. The question is did they know their real names? And when you look at the trial testimony, which happened in
This isn't an identity case. This is a what happened.
this, exactly. These are eyewitnesses that all saw what happened.
Except all of them didn't see all that happened.
Well,
You had some witnesses who said, I heard something happening behind me. When I turned around, the victim was on the floor bleeding.
Yeah.
So he didn't see. He responds to a sound and turns around and makes an observation.
if I may respond to that, Your Honor.
Yes.
That is Anderson Almonte. He's the only witness that said my back was turned. With regard to Luis Rodriguez,
That's the person who I was referring to, counsel, Mr. Almonte.
All right, you'll have time on rebuttal.
okay.
Good afternoon, Your Honors. May it please the court, my name is Jared Walkowitz for the people. Your Honor, I just think we need to step back and explain, and I would like to explain the procedural history, because I think what they're trying to do is conflate issue upon issue. There was a trial, and the defendant was found guilty. He then proceeded to submit an affidavit and a 440 motion with 3 witnesses. One of them, who Your Honor said testified at trial, Anderson Almonte. Another one was Luis Padilla. And another one after that was Carlos Ventura. The court then rejected that motion. And one thing counsel said that was completely not accurate was that the court never assessed the credibility of Padilla. The original court did. And they said that the reason why Padilla may have not testified, and it was not ineffective assistance, in the context of ineffective assistance of counsel, was because there may have been credibility concerns because of the difference in testimony between Padilla and Almonte, even through the affidavit versus the trial testimony of Almonte. And they submitted Padilla's testimony at the Ventura trial, which was the second trial that happened here. So the court did analyze it and realized it was a strategic decision that could be explained, and that is, in essence, a ground in which the court can deny an ineffective assistance of counsel claim.
So is a hearing required or not?
What's that?
A hearing, would it be required or not?
Absolutely not. The judge, this is what I was going to get at, Your Honor, is this was essentially, this court denied leave on those 3 applications. This, in the end, was basically a rehash. The second motion that this court granted leave was a summary denial based upon, they were arguing the same thing: ineffective assistance of counsel, newly discovered evidence, and actual innocence. And they didn't make it out, and the judge saw that and said, it's the same thing. They basically added Luis Rodriguez, just one more witness who had the same information that the court previously rejected, and there was no grounds for the court to consider the motion, so they summarily denied it. Now, so there's no basis for a hearing, and plus, as I said in the first motion, which counsel so desperately wants to relitigate, which this court denied leave, the trial court went through credibility, and of course you could judge credibility on affidavit. Carlos Ventura lied in his affidavit. He said he was acquitted of all charges. He was not. He was convicted. So the court obviously saw these affidavits for what they were worth, and he denied it on the papers, which he has the absolute right to do, and despite counsel's. And then when the motion came back up and there was a rehash of it, he saw it for what it was worth. It was just another try to get a bite of an apple. And I guarantee.
Counsel, the rehash also concerned Almanzar's testimony and also Mr. Veras' trial testimony at the co-defendant's trial. That was available on the first 440 motion, correct?
That's correct. Everything in the second motion was in the first motion, with the exception of Luis Rodriguez's affidavit and the claim, Your Honor, regarding ineffective assistance with regard to Luis Rodriguez not appearing in court. And again, as Your Honor was talking about before, Justice Pitt, in terms of due diligence, the only thing they ever wrote about Luis Rodriguez was he was obtained as soon as possible. There's nothing from first counsel what he did. Nothing from defendant what they tried to do. Nothing from Luis Rodriguez. They had Luis Rodriguez write an affidavit. He could have explained everything, where he was, his whereabouts, all those things. They did nothing. And they came and they just threw everything against the wall and said, let's have a hearing. That's not sufficient for a hearing, Your Honor. If there are no further, are there any further questions for me? If there are no further questions, I'll rest and ask you that you affirm the conviction. Thank you very much.
Thank you. You may proceed.
Specifically, just want to address something quickly with regard to Carlos Ventura. Carlos Ventura was acquitted of all the robbery charges. And there's a big difference between Carlos Ventura's trial and Mr. Medina's trial. And the fact of the matter is Carlos Ventura testified at his trial, and Martin Padilla testified at his trial, at Carlos Ventura's trial. There's no way we know, unless the court can assess the credibility, what was the difference between Arturo Medina, who gets convicted of all the robbery charges and acquitted of the grand larceny charge, and Carlos Ventura's trial, who's acquitted of all the robbery charges.
Well, they're not all charged with the same acts, right?
No, they
Your
were.
client is the one who is alleged to have struck the victim, correct?
That's correct.
Okay.
But they were.
Whereas the other ones, one was either a lookout, et cetera. One was picking up the phones, but had no physical altercation with anyone.
Well, he picked up phones and took money, but they were all charged with robbery.
I understand that.
Yes.
But they weren't all charged with doing the same, having the same acts of participation.
Well, the
In
theory.
any case, we have your arguments. Thank you, sir.
Okay.
Case of Rivera versus Shipri Realty. You may proceed, sir.
Thank you, Your Honor. I'm frankly not used to responding to an argument that I haven't heard. Basically, as a former plaintiff's attorney, plaintiff's counsel, in this particular case, made every procedural mistake you could make from the moment they filed their first complaint until the case was dismissed, and then they asked for a do-over. There are a lot of ways in which the court can show a little leniency in allowing for certain errors, and I submit that these errors go way beyond that. But the most important thing is the last point, which is they can't prove the case.
Right.
Plaintiff, who's the only person that knows where this accident happened, died. No testimony, no bill of particulars. They have no case. So if the court has any questions, I'm happy to answer them. Thank you. Have a lovely afternoon.
Have a good day. All right. Job versus Chelsea Hotel owner. You may proceed, sir.
It pleased the court. I'm Mitchell Heaney. I represent the appellant's tenants in this matter. As you know, it's an appeal from an order in judgment which dismissed the complaint in its entirety pursuant to CPLR 3211. Given the detail alleged in each cause of action, this ruling flew in the face of the frequently recited standards of review for such motions. It was as if the court while reciting these standards of review, lost sight of their continued vitality and application in deciding the motions. Principally lost was the standard that in a complaint, the misconduct complained of must be alleged in sufficient detail to provide the defendant notice of the substance of the claims, as set forth in this court's decision in Robinson v. Day, 103 82nd 584. It's quoted in our brief. More detail than that was not required in the complaint, where the causes of action as alleged provided more than adequate notice to respondent of the substance of the claims.
Counsel, is there enough detail concerning Mr. Pass's harassment claim under the administrative code?
I'm sorry, Judge, I could not understand.
I'm sorry, plaintiff Mr. Pass
Yes,
is bringing a harassment claim under the administrative code.
yes.
There's not very much in there about how he was excluded from his backyard. That's the claim, right?
Well, it's alleged in there that they tried to deprive him of the garden area, and that after he resisted that, they then threatened that they would attempt to do so again. That's one branch under the statute as to which Mr. Pass was seeking a finding of harassment. In addition, like Linda Job, he is aggrieved under that statute in terms of the panoply of essential services that these people have been deprived of since, and including November 2013, as alleged in the complaint. But, may I go on?
Please.
Also lost sight of in dismissing the complaint was that the complaint is not an affidavit seeking summary judgment, and it's not expected or required to be bolstered by evidentiary materials or proof of material facts, which is essentially what was going on here in requiring the plaintiffs to provide more than sufficient notice of the
So, counsel, what you're saying essentially is that the, all the language that's set forth in the.
I'm sorry, Judge, I'm a little hard of hearing. So
I talk low. So what you're essentially saying is that the litany of what could be housing code violations are set forth in your causes of action. Windows left open in the winter, cutoffs with respect to heating, rat infestations, and so.
That's
so on
correct.
and so
Paragraphs 48 and 58 of the complaint.
Right. So you're saying that it's your view that the complaint has enough detail, and if dates have to be fleshed out and so on, it can be done further on down the line?
I just couldn't hear the end of that, Judge.
So what you're saying is that enough information is provided in the complaint that further details can be fleshed out further down the line?
That's correct. I mean, there's no doubt what the claims are. I mean, there's adequate notice of the claims. It goes well beyond that.
And a motion to dismiss doesn't require the specificity of dates, does it?
It requires some specificity sufficient to give notice of the substance of the claim. I would submit, though, that with regard to the conditions in the apartment, those allegations at paragraphs 48 and 58 of the complaint do far more than that. I mean, perhaps the best indication of that is what the court itself found, even in dismissing the complaint. I mean,
Counsel, what about the allegations concerning the lease? A copy of the lease is not included in any of the papers.
That's correct, but the
problematic?
allegation is there.
Is that problematic here, where it's a motion to dismiss?
I don't think so. It provides sufficient notice of what is in the lease, and that in the lease, the appellant's rights are of the nature and substance as alleged in the complaint. It's therefore notice of what's alleged. It's therefore notice of what's in the lease, which is the point.
Counsel, as to exhausting the administrative remedies, is your is your client entitled to injunctive relief without doing so? Is that necessary?
Well, it is not necessary, to exhaust administrative remedies to vindicate a contractual right. I mean, what we're talking about here is an issue of contract, an issue of what the leasehold right is as alleged in the complaint. To my knowledge, the DOB has never been the arbiter of contractual rights between private parties. Yet, in requiring that administrative remedies be exhausted before tenants in this instance can assert their contractual rights to, in this instance, a certain form of heat, is not within the purview of the DOB. There's no administrative remedy to be exhausted. They don't.
Thank you. You'll have 2 minutes on rebuttal.
Okay, thank you.
You may proceed.
Good afternoon. May it please the court. My name is Jennifer Racine, appearing on behalf of Chelsea Hotel owner. I think some of the questions that were raised by the panel earlier really go to the heart of the issue. First, as the appellant ended with, the claim is to vindicate certain contractual rights or lease rights, and notice that there is no lease attached.
Why does the lease have to be attached to the complaint?
It doesn't need to be attached, but at least, and just bear with me because we don't have a copy of the lease. We're a successor owner.
That's not.
I understand that's neither here nor there.
Sorry, what did you say to me?
But certainly.
I didn't hear what you said.
Oh, I said that's neither here nor there. I understand your Honor's point. But to say what the lease says, to characterize it, is not enough. You must quote the lease.
Why?
Because otherwise, why?
This is a motion to dismiss a complaint under 3211, am I correct?
Correct, and there has to be sufficient notice. We asked, we said, can you show us the provision of the complaint? And this goes to the most important aspect of what is missing here.
So get the lease for the party that you bought the building from.
They don't have it. No, nobody has it. That is the problem. The only person
you
who
get it
has
in discovery.
Exactly.
Excuse me?
You get it. I'm surprised you can't hear me. I'm very loud. You'll get it in discovery.
Your Honor, so this is why we shouldn't get to discovery. Even if you believe that simply characterizing what the lease holds without attaching the lease or even quoting the lease is enough, even if assuming that, what this is entirely devoid of is not only dates, doesn't say when anything happened, so I don't know, did most of these things happen prior to the statute of limitations? I can't tell. Chronic should be followed by a time frame. One, and two, and this is the most important part, nowhere here does it explain that the tenant came to the landlord, told the landlord, this is a problem, my lease says this, you're doing that, please fix it. And that's because none of that happened. All of those facts are within the plaintiff's control. This isn't the kind of case where there's—
It sounds like you expect this case to be tried before discovery even commences.
There is no, unlike a fraud case.
According to you, there is a need for discovery because you don't even have the lease.
That is correct. I do
right?
not have the lease.
So discovery is needed.
No, I don't think it is, because it would be very easy. There has to be some burden on the plaintiff to come forward with facts. If the plaintiff has a lease,
They've
this.
said, counsel, I need you to calm down
Okay,
because you shouldn't talk over the court.
my apologies.
Okay? The complaint very clearly says the lease requires me to get for free steam heat. They don't have to quote the exact language in order to inform you that they assert that their lease requires the landlord to provide free steam heat. So it then is up to you to come forward with evidence to the contrary. And if you cannot, it seems to me that that is sufficient on a 3211 motion of this nature.
Respectfully, I disagree. Your Honor, and I will explain why. Because the fact that it is not cited here, and I suspect that this is what's going to happen, the fact that it's not even quoted, forget attached.
Counsel, this is a very curious situation because doesn't the defendant own the building, it owns the hotel.
It does.
And it owns this building.
Correct.
So if it doesn't have a lease, whose problem is that? You'll get your documents in discovery. If the owner of the building didn't do proper record keeping, does that problem fall in the lap of the plaintiff tenants?
It would be if nobody had the lease, but somebody has the lease.
I suggest you go on to the next issue.
Yeah.
Because this is not a winning issue for you.
Oh, okay, well, at what point did anyone come to us? Where is there an
Counsel,
allegation?
I suggest you go on to the next issue. Do you want to be heard on the issue of warranty of habitability?
This all goes to warranty of habitability.
Yes, it does, and the allegations in the complaint that there's rodent and rat and insect infestation, freezing conditions, lack of building security, waistline failure, changing in the heating system to space heaters, electric space heaters. Those are the allegations, some of the allegations regarding the breach of the warranty of habitability. Could everybody hear me, I hope? I guess so.
Know when, know how long, know.
They said from November 13th, I believe the complaint says. And she says, and the complaint also said that it was the landlords or the caretakers for the landlords who were placing garbage in the tunnel underneath her space that was causing the rat and insect infestation. So I think those particularities are quite specific.
It doesn't say when, so we don't know. I understand you're saying it's after November 2013, but it's a 3-year statute of limitations. So we're in 2021. Again, why would the court allow us to litigate without having a quotation from the lease, having a date when it's a thing particularly happened? I would ask the court.
Counsel, are you confusing a motion to dismiss with a motion for summary judgment?
I certainly am.
Are you confusing a complaint with a bill of particulars?
No, I am not.
Thank you. We're out of time. Counsel, I believe you have 2 minutes. Thank you. People versus Javon Campanioni. You may proceed.
May it please the court, Taylor Poore with the Office of the Appellate Defender for J. Van Campanioni. The federal predicate used to enhance my client's sentence was not the strict equivalent of the comparable New York statute. The DA has conceded that the federal statute fails strict equivalency with Penal Law 22039 because the federal mens rea is broader. But the DA's alternatives also fail the strict equivalency test, and that's because they also require the same mens rea as 22039, knowledge of a specific drug, while the federal statute just requires knowledge of a controlled substance in general. And so the prosecution is wrong that there is some New York statute out there available other than Penal Law 22039.
Counsel,
Yes.
this court has held numerous times in many cases, I'm sure you've read them, that this particular federal statute is in fact the equivalent of the 22039 penal law statute here in New York State. Why should we change that now?
Because the court has never confronted this particular argument that the mismatch is with the intent. So that has never been argued before, it's never been raised, and this is the first time that the court has the opportunity to consider that mismatch. And for that reason, there is a mismatch, and 22039 is not the strict equivalent of the federal statute in this case, so it cannot serve as a predicate to enhance my client's sentence. Now, understandably, the prosecution has also never previously made the argument that there is another statute available than 22039. So that argument, which the prosecution is now making for the first time on appeal, is completely unpreserved. The cases the prosecution cites are, in fact, very good examples of how in New York, the proof of intent has to match up with the specific substance charged, which is just not the case in federal court. And so I think that's probably the easiest way to think about it, is that the intent always, whether it's an attempt charge, possession, or sale, the intent has to match up with the specific substance charged.
But the specific substance charged would in fact still be a controlled substance, right? It is the equivalent.
So the specific controlled substance charged is what the intent requirement is in New York, but in federal court, all that is required is proof that the defendant knew they had something that was a controlled substance. So there is still a requirement that the defendant was aware that it was something illegal, but the specific substance itself is not part of the burden of proof in the federal court, unlike in New York. Another way to think about it, I think, is, for example, if a defendant were selling a substance that was actually heroin and believed that it was cocaine, in New York, the available conviction could be attempted cocaine sale, while in federal court, the charge and the conviction would be heroin sale. So there's a different focus there. Obviously, in both cases, the client or the defendant could be convicted of a serious felony, but they are not, the statutes themselves are not equivalent.
Counsel, could you briefly address the appeal waiver?
Absolutely. In this case, the oral colloquy did not distinguish my client's trial and appeal rights, so did not distinguish my client's trial rights from his appeal rights, and it also implied that no appeal rights survived the waiver of appeal. Those two flaws, even before we examine any other part of the colloquy or the written appeal waiver, those two flaws made this appeal waiver involuntary under the two most recent decisions from the Court of Appeals addressing waivers of appeal, specifically People v. Thomas and People v. Bissono. And so for that reason, this court absolutely can reach my client's request for a sentence reduction of 6 months in this case. If the court has no other questions, I can address them on rebuttal. Or if the court has any other questions, I can address them on rebuttal.
Thank you. You may proceed.
May it please the court, I'm Philip Tisney for the respondent. In People v. Vasquez, this court held that a conviction under 21 U.S.C. 841 is a valid predicate in New York. Nothing has changed since then. The federal and state statutes are still the same.
Counsel's argument is accurate, though, no? That the specific issue was not addressed in that case? That's
Certainly.
raised here is not the exact issue raised in Vasquez.
As far as the briefs and as far as the decision are concerned, that's correct, Your Honor. To my knowledge, I don't have any access to the internal memorandum of the court, what the court considered, but going on the public materials, yes, certainly that is correct. And that's part of the reason why we talk about things in addition to 22 or to 2039 in this case.
But was that discussed, was that argued below?
What was argued below was that Vasquez is good law and remains good law.
My question was, did you argue with respect to 2039 below?
There was no
Did you
requirement to, because the only point was in that court that Vasquez binds it and is controlling. They can come into the trial court and say, listen, we understand that you don't agree with Vasquez, and there are reasons that we think that you should not follow Vasquez. But the only response to that in the trial court is, that's great, but the trial court's bound by it, of course. The only court that can overturn Vasquez is this court or the Court of Appeals. And so while the argument is still the same, it's a little different there than it is here. And that's why you have the sort of more expanded response to their arguments about the federal knowledge requirement. Now, if I can get to the federal knowledge requirement.
In this instance, though, the trial court made reference to People versus Vasquez. Is that correct?
Exactly, because the argument was, listen.
I just have a little bit more to the question. And in People versus Vasquez, the conviction was to 2039.
The court said that the 841 conviction in that case would be the equivalent to 2039. Yes, that's correct. And as they say, they are raising arguments that weren't addressed in Vasquez, which is part of the reason why we need to talk about more than 2039. Now, getting to the knowledge requirement issue, they say that federal law is broader than New York law because under federal law, but New York, and this is their claim, under federal law, but not under New York law, a person could be guilty if they possessed one controlled substance, but they thought it was a different controlled substance. In New York, that person is going to be guilty of a felony in at least 2 ways. The easiest way is through the attempt provision. A person in New York who possesses salt or who possesses talcum powder but thinks that they possess heroin is guilty of a felony, either attempted possession in the 5th degree or attempted possession in the 3rd degree. They've admitted that in argument. They admitted in their reply brief at page 10, that's the ballgame. If conduct that would constitute a violation of the federal statute would also constitute a felony in New York, the statute is a valid predicate. You don't have to go any further than the attempt provision to see that. Now, we've also...
But there have been cases that, and I think counsel was alluding to People versus Tremuta, where the charge was for the sale of LSD, and the person actually believed that it was mescaline.
That's correct.
And the court held that you could not hold that person responsible for possessing LSD when what they actually possessed was mescaline.
Exactly. Well, that's not quite true. But Tremuta is a great example of the second reason why somebody who possesses one controlled substance but thinks it is another controlled substance would be guilty of a felony in New York. You don't have to rely on the attempt provision to get guilt in that situation because the person would be guilty of straight 5th degree or 3rd degree criminal sale of controlled
right, where the substance did not have to be known.
Exactly. So
which is her point.
Well, in Tremuta, for instance, the defendant possessed LSD, was charged under a statute that particularly prohibited the possession of LSD, but at trial, she proved that actually she thought it was mescaline. And so the court said, no, you can't be guilty under the LSD provision because there isn't any proof that you knew it was specifically LSD. But, and this is the critical point, you can be guilty of the generic controlled substance provision because that doesn't require proof that you knew the substance that you possessed was the substance that you thought it was. She possessed LSD, right. That's a controlled substance. She thought it was mescaline, that's a controlled substance. Ergo, she is guilty of knowingly possessing a controlled substance.
Right.
This is the point that we've made in the brief.
Counsel, I'm going to ask you a quick question. Let's assume for the sake of argument that we agree with appellant that the federal statute has a broader knowledge element than the penal law. Why shouldn't the defendant's sentence be reduced?
Well, so our argument on this point has to do with an understanding of what the sentence reduction is going to do in this case.
I'm sorry, our understanding is what?
I'm sorry?
She couldn't hear you.
I'm sorry. Our argument about the sentence reduction in this case really hinges on how the sentence reduction here would operate. The 6-month reduction that they're requesting in all intents and purposes is going to have any effect only if this defendant either violates his PRS or commits another crime. And our whole point is that if that's going to happen, then if he's going to get the benefit of a sentence reduction, it should be the authority that is adjudicating either the PRS violation or the new crime that should decide whether he deserves to get a break on this current sentence. Shouldn't do it prospectively. That's all our point. And can I just address that one last point in a little more detail?
You're out of time. Sorry.
Thank you. We'd ask that you affirm the conviction below.
Thank you. Counsel, you have 2 minutes.
Before you start, if you could just address your opponent's last point in terms of the anticipation that your client will commit a new crime as the reason why there should be a sentence reduction, as opposed to waiting for that event to happen. If and when it does, it might not happen.
The sentence, anybody's sentence, a sentence has multiple aspects and multiple consequences, one of which is undischarged prison time that is under consideration throughout a term of post-release supervision. And that's just as meaningful of a consequence of a sentence worthy of reduction as any other consequence, which is part of what, so Mr. Campagnoni's request for a sentence reduction is just as meaningful when it's applicable to the undischarged prison time.
In anticipation that there is going to be a new crime?
I'm sorry, Judge.
In anticipation that there will be a new crime? Why not wait for
Or
any
if,
violation to actually occur if it might not?
I'm not sure I'm quite grasping the second part of your Honor's question.
My question is, and this is what your opponent argued, that the issue of a sentence reduction, if it were to occur, should be addressed by the court and when it happens in that particular court, right? If someone is rearrested, then they're going to be held for violating their post-release supervision, whatever new charges, whatever case may be. Why not wait for that event to happen? As opposed to you saying, well, in anticipation, he might commit a crime, so let's handle it now.
I understand, Your Honor. Thank you for the clarification. I think the anticipated future sentencing date is absolutely the appropriate time to talk about that. Hopefully never happens, that particular case and the sentencing considerations in that case, if I could just finish my answer briefly.
Yes, you may.
Right, but at this point is the correct time to request a reduction in the undischarged prison time that my client already has, partly because the reduction is not just, the requested reduction would not just impact the sentence that the undischarged prison time that we've been, in the context that we've been discussing it, but it would also move the maximum release date of my client backward by 6 months, and it would also reduce the amount of time hanging over his head in the future, even after the post-release supervision date term was complete. In fact, the main argument I'm making here, which is that my client should be entitled to resentencing as a first felony offender, is in consideration of his future. He has a family, he has a loving daughter, and he deserves every opportunity to not live under a harsh and excessive sentence, which remains the same. Thank you.
Wu versus Torres. You may proceed.
May it please the court, Tim O'Shaughnessy from Transit. Unfortunately, we don't have a bus video, we don't have any non-party witnesses, and we don't have situations that we sometimes do that the vehicles remain in location at the time of the collision so the transit supervisor can come and do some measurements. Now, we must remember, this is plaintiff's motion for summary judgment, so all of the testimony offered by the defendant must be taken as true. The bus driver's testimony is that he passed the car, it was behind him, he was stopped at a red light.
Counsel, is that testimony clear? That's, you're quoting from record 433. He says the minivan was 1.5 car lengths behind me. Is that from the driver's seat or behind the bus? Is that clear?
Well, we don't know. We don't know that. Although the fact of the matter is, either way, he's behind. And in fact, the plaintiff's testimony was that, well, the plaintiff first testified that he was 2 bus lengths from the light. Then he said, well, I don't know how far it was. But in any event, the bus driver's testimony is very clear that the bus driver barely began to move when the light turned green, the van came. First he saw the van, it clearly had moved, and was much closer to him. Then he looked away briefly, and the next thing you knew, he heard something, looked in the mirror, and the van was in contact with his bus, and so he stopped. In addition,
Isn't there a discrepancy between what he said initially in the accident reports and what he testifies to, where he acknowledges and admits that he never saw the car move?
He said...
Initially, he said, oh, no, the car moved. He was trying to squeeze past me, etc. So it seems to me that is like a stark red flag for feigning a different story.
Well, no, in the passage at his deposition that's quoted in our brief, he explains he saw the car, it was not moving. Then he saw it again, and it was right on top of him. So he did not see the car.
He said he never saw the car move.
Yes. Well, what he meant was,
What he
did not
meant?
see it in
Now,
motion.
now, come on, you know that is not the way that we
Well,
decide
then
these
it's, well,
cases.
frankly, Your Honor, in that event, it's a question for the jury. Did he?
Is it?
Yes.
I have him say the car did not move.
But he also,
I didn't see the car move.
but he also said the car was behind him, and then it struck his bus after he moved a foot. So that would be a question for the
So
jury.
this car smashes into the wheel of the bus such that he allows himself to get pulled by the bus with such force that the car goes up on a 45-degree angle and both the tires blow out.
That's,
I mean, that is what this bus driver expects us to believe.
that is the plaintiff's testimony. And so we're taking the bus driver's testimony as true, and that is that it was the car that caught up to the bus and caused the two vehicles to come in contact.
So, counsel, I want to ask you something different, which has to do with the police accident report. So we know that the plaintiff supplied the first page of the police accident report and made reference to the bus driver's statement. And then we know that the defendant submitted the police accident report in its totality, and on page 2, there was the plaintiff's statement. So my question to you is, should we treat this as hearsay to the extent that it's just a piece of paper and you can't rely on you can't find that there's a tribal issue of fact because the plaintiff on the second page says that he was waiting for the light, he was in the right lane, whereas the bus was in the left lane, and they were waiting for the traffic light to change, as opposed to the plaintiff's I'm sorry, it's a very long question, as opposed to the plaintiff saying initially, I was in the parking lane, I wasn't moving anywhere, I was waiting for my family to get into the car. What do we make of all of that? Is this just?
Well, we cite cases for the proposition that by citing one page by submitting one page of the police report, the plaintiff has waived any objection to submission of the entire police report. But actually, the question is moot because a similar statement by the plaintiff appears in Transit's supervisor's report, to which plaintiff did not object, and that is the statement that the...
Did the plaintiff get a chance to see that accident report prepared by your people before it was submitted?
I don't recall, Your Honor.
They never do.
They
The
should have.
answer to that question is no, because your people never give the people with whom they have an accident a copy of your accident report at the scene.
Well, they should have gotten it in discovery, and they didn't complain in reply below that it had not been turned over in discovery.
All right, you have time on rebuttal. You've got 5 minutes, sir. You can proceed.
Good afternoon, Your Honors. Nice to see you again. Chris Savro, Pollock, Isaac, and DeSico on behalf of the plaintiff. It seems like you all have the legal issues and the facts fairly in your hand, and as you always do. The one thing I'd like to point out real quickly in terms of the facts is that the defendant also testified that when he passed the vehicle...
I'm sorry, who testified?
The defendant. The defendant testified that when he passed the vehicle, he decided to pull around it because it was off. And after he pulled around it, he cut it off. He decided to wedge in front of it so that it couldn't get by him. That's his testimony. It's off. He wedges in front of it after he pulls around. This is entirely consistent with exactly what the plaintiff testified to, which is, I turned my car off, my family got out to take a picture of the bull, I waited for them to get in, and the defendant said it looked like he was waiting.
What do you make of the plaintiff's statement referenced in the police report that the plaintiff was waiting for the light to change as opposed to having his family get into the car and just be perfectly stationary?
Okay, I can say a lot to that. It's an uncertified police report. The police officer wasn't a witness. The police officer didn't certify that he took it.
Let me stop you for 1 second. You submitted page 1, right?
Correct, Your Honor. It was submitted as part of the notice of claim. It wasn't relied upon as part of the argument or the prima facie proof of the plaintiff. And in fact, at the deposition testimony, the plaintiff denied ever even being interviewed by the police officer or giving that statement. That's at page
So
180
does
of the
that create
record.
an issue of fact, is a triable fact for a jury to decide? Or
No.
are you saying that there was no reliance by the plaintiff on the police report by submitting it in the notice of claim?
Yeah, yes, Your Honor. In terms of summary judgment, he didn't rely upon it to carry his prima facie proof. The cases that they're relying upon say that when a plaintiff merely submits as an exhibit a police report, therefore he waives admissibility, and that's not true. In fact, I'll take you back to 2017. Justice Mazzarelli may remember this. I used to be a defense attorney. I tried to make the same argument in Thompson versus Pizarro. I got ripped apart.
You tried to, you know, the masks are a pain in the neck.
I know, Your Honor.
So you what?
I made the same argument as a defense attorney. I said, look, there's a police report. They cited to it. They included it. It raises an issue of fact. I was slaughtered. Thompson versus Pizarro went completely against me. And you know what? I disagreed with it back then, but that's the ruling of this court. We have no choice but to rely upon it. You know, I made the best case I could back then, but I lost, and the same result.
We don't slaughter lawyers, we just rule against them.
Excuse me?
We do not slaughter lawyers, we rule against them simply.
Okay, I went out in a blaze of glory then. Okay. But
I have a factual question. Is this one of these long double buses or just a regular bus?
I believe it was a regular bus, Your Honor. And the regular bus at the rear right wheel, everything, every piece of evidence, whether or not it's certified, whether or not it's hearsay, all aligns with the simple fact. It grabbed the plaintiff's car by its left fender, pulled it forward with such force that it destroyed 2 of the tires. Now, defendant says, I never saw it move. It was off. I didn't feel an impact until I started moving at the stoplight again, which again is very consistent with what the plaintiff testified to. Plaintiff said, he crashed into me, he pulled me forward, then he stopped. Then he moved again. That's exactly what happened here. There's no triable issue of fact other than a feigned issue of fact that they're trying to raise by what's clearly hearsay statements, and they're trying to twist these hearsay statements. Even if we say plaintiff relied upon some portion of it, they still need to prove an exception to the hearsay rules on 2 instances, and they completely failed to do so.
And you're saying they failed to do so because these were not certified police reports, a certified police report or a certified supervisor's report?
Well, it's the lack of certification. It's also the lack of any attempt to say, what's the exception, right? If we're looking at it from a business records point of view, they have to show that these sorts of statements are taken in the regular course of business. There has to be indicia of reliability, such as it being sworn to under oath, which wasn't done here.
And it's not a party admission, right? Because it's the police officer saying it, not the plaintiff.
Correct, Your Honor. And typically with party admissions, right, party admissions are typically brought in, or say past recollection recorded is brought in when the witness isn't available. Witness is available here with respect to the plaintiff, and he denies ever making the statement, and he denies the truth of it, and there's no proof to the contrary. The police officer isn't in here saying, no, I took this statement, it was completely accurate, I have, you know, a completely accurate memory, a photographic recall, and this is exactly what happened.
So you're saying an affidavit is missing?
Excuse me, Your Honor?
You're saying that an affidavit is missing?
Yes. Typically, if you want to get a police record in, you have to have it certified. You also have to have the police officer's testimony, or it has to be a signed, sworn statement by the person who actually signs it. And that's a, if you'll bear with me for a second, there's actually a Court of Appeals decision on that point. And that would be Kaufman versus Quickway Incorporated, 14 New York 3rd, 907, at 908 through 909 of 2010.
Thank you. You are out of time, my dear.
Okay, thank you, Your Honor. It's great to see you again.
As I mentioned, plaintiff did not challenge the admissibility of the transit supervisor's report.
You mentioned earlier that the transit supervisor did not appear at the scene of this accident, correct?
No, I only said that he did not do a drawing. His supervisor's report says, I interviewed the van operator, and this is what he said. So both what appears in the police report and the transit supervisor's report says that the plaintiff said something about the car being in motion and about the bus starting to move and the bus turning that is completely inconsistent with the plaintiff's deposition testimony.
Except that the plaintiff does not acknowledge talking to your person.
Well, there's an issue for the jury.
So you're saying anytime that a transit supervisor claims to have spoken to a driver of a car accident, that's it?
if it's admissible.
That's
And
it? That's
and
all that's necessary?
To create
Your
a-
people create a report.
To create,
It's not observed by anyone, it's not signed by anyone, not verified by anyone, and that's enough to create an issue of fact?
if it's admissible, the transit supervisor had a business duty to record it, and what he recorded, the plaintiff saying, was an admission because it is completely contrary to the plaintiff's deposition testimony.
Well, it's not an admission because the EBT hadn't occurred yet, right?
I'm sorry?
The statement that your transit supervisor claims he took from the plaintiff is not a admission that's contrary to an EBT that had not happened yet. Correct?
In New York, an admission is something that,
Counsel, I know what an admission is in New York.
It's
My
in-
question is, at the time that the statement was made, there was no EBT, right? That happened later.
well, Your Honor, I guess we disagree. I think that what the time that matters is trial. If the document says the plaintiff is admissible and it says the plaintiff said something that is contrary to the plaintiff's position at trial, then it comes in as an admission.
Okay, thank you.
Thank you.
All right. Neubauer versus City of New York. You may proceed.
Thank you. Good afternoon. May it please the court, my name is Chris Murray. I'm representing the appellants in this matter. The respondents made a discretionary policy decision to discontinue one type of housing for the homeless, cluster housing and hotels, and replace them with large community shelters. When they made this decision, they had undertaken no secret review whatsoever. This decision was not speculative or something thought about in the future. This was a concrete decision. They acted upon it. They began closing the cluster housing and began building the community shelters. There was nothing not definite when the decision was made.
But counsel, I mean, the other side makes a very good point. It seems to me that a global assessment would be impossible at the outset of the Turning the Tide plan, because you don't know where you're going to expand, you don't know where you're going to site, you don't know which not-for-profit is going to work to create the new type of housing, so that it's not an integrated plan. That the Supreme Court put it very well, I think, by saying these are temporally and spatially heterogeneous projects, very spread out. So there's just no unity here. So how could you possibly do a secret analysis of something that has so many moving parts that will come into play over a period of years?
Well, you can make a determination and you can look at mitigating factors for the idea of closing a type of housing and building a different type of housing. And that decision, it's like a zoning, the Pine Bush case with the Court of Appeals. They said that the zoning triggered the secret review requirement, not the individual development of a particular parcel. So when you're having the triggering effect is the decision. And the decision was to close a type of housing and open a new one. And the specifics of where those new locations would be were not relevant to the environmental review that was required.
How could they not be? How can you do a secret review and assess the environmental impact of a new project without knowing where that project would be?
Well, you knew they were going to close cluster housing, and you knew they were going to open community shelters. There are steps that can be reviewed. There's generic environmental impact statements that are done all the time, where they do a generic environmental impact statement for the policy.
And then there would be litigants coming in here saying it wasn't specific enough.
No, because they do the generic one, and then they
do it again when they pick
when they
a
have
site?
specific locations, they supplement.
Let's not do it once, let's do it 2 times.
No, because there is a fundamental policy in New York State that environmental factors should be considered when discretionary decisions are made by a governmental body. Here, there was a discretionary decision to close a certain type of housing and open community shelters, and that required a secret review. Whether they find a negative declaration, they do a EAS, they do a full environmental impact statement, that would depend on the process. But that process had, because otherwise, if you look at only one specific location, the adoption of a policy that affected more than 10,000 people, 90 locations, and a whole shift in the way that homeless were going to be housed was adopted without any environmental consideration.
Council, let's assume that we agree with you that this was a massive overhaul of housing policy, homelessness policy, and so on and so forth. I'm looking at the description of the RFP, the request for proposals, where it says this is an open-ended request for proposals. Therefore, there is no prescribed due date for submission. All suitable proposals will be reviewed by the agency on an ongoing basis as received. In that context, I piggyback on the questions that were raised by my colleague. How do you possibly do secret review if it's not on a one-by-one, case-by-case basis?
You look at what the effect of the policy change would have on the environment. You can figure out mitigating factors.
How do you
determine.
How do you know the effect on the environment if you don't know where the locations are?
You know that there's going to be a certain type of housing closed and new type of housing built. And it's the same. It's same with zoning. The exact same as like Save the Pine Bush with the Court of Appeals decision.
But that talked about a specific geographic area, right?
Well, you have a geographical area
Yeah,
here.
but New York City is not exactly the same thing. It's like humongous.
But then if you determine that it has to be by location, the determination to close a certain type of housing affecting 10,000 people will have no secret review. And that, I believe, is a violation of the law.
Okay, you'll have time on rebuttal. You've got like 10 seconds left.
Okay, thank you, Your Honor.
You may proceed.
Good afternoon, may it
So,
please.
counsel, before you even say anything, I'm sorry. In this situation, as presented to us today, has the state and the city, have they done an end run around us by gutting SECRA with an S and SECRA with a C?
I'm sorry, I don't think that's the case here, Your Honor.
Well, if you say that the overall policy cannot be reviewed, and I should call it a city policy, I'm sorry, I shouldn't. If the overall policy cannot be reviewed and you have de minimis review, where the individual projects are concerned, such as the de minimis review that the appellant claims happened here, are the two statutes gutted?
I don't believe that's correct, Your Honor, because I would dispute the fact that there was de minimis review here. The proper amount, a hard look was taken at the shelter, and that is the appropriate time to review the environmental impact of these individual projects. While there is an overarching policy to move away over time from one type of housing to another, That is a broadly conceived scheme that depends in large
a
part.
broadly conceived
Scheme.
Scheme or initiative, Your Honor, that depends in large part on certain assumptions that have been made, and that those assumptions will continue to be true. And the plan itself recognizes that continued housing policy has to remain the same. I mean, the timeline for this is across administrations. So we are assuming that the next administration will continue with this policy. But it is impossible, as other members of the bench have pointed out, to begin to review something where you don't know the location, you don't know when, you don't know by whom, you don't know how many people will be housed, you don't know what type of housing it will be. All of these questions have to be answered before you can begin to say, how does this impact the community? How does this impact neighborhood character?
So let's move away from the review of the overarching policy and talk about the review of this particular development at
Yes, Your
this
Honor.
particular location.
Mm-hmm.
Why was the review? Why was it adequate?
What is required is that a hard look be taken at those areas where there's potential for environmental concern. The secret technical manual lays out thresholds and guidelines for this analysis. And those thresholds and guidelines were complied with in this case. In fact, my opponent has not pointed to any way.
So why don't you tell us why there was compliance?
Okay. There were 3 areas that were identified for additional study. And of these, my opponent has only disputed transportation. They have argued that parking was not considered. But a traffic analysis was done. And under the terms of the secret manual, they did an adequate analysis because an insufficient number of peak hour trips were estimated to result from this particular project to require a deeper, more detailed analysis. And this court has recognized that compliance with the secret technical manual constitutes a hard look and constitutes compliance with SECRA. And the fact of the matter is they also considered, would there be an impact on community facilities? You know, the fact of the matter is that this is not a large neighborhood. This is a 200 person shelter in an area where it won't have an impact on schools because there's no children involved, so public education won't be strained. And they asked whether or not—
This was originally devised as a men's shelter. Is it that way now?
It's a women's shelter now.
It is it occupied now?
I believe it is, Your Honor. It was occupied in 2019. It opened, and it was operational without incident for a number of months. And as you know, there's, and so the—
Counsel, I think you're about to start talking about the pandemic. Now, that returns me to whether we can do a SECRA analysis of the whole program, the whole Turning the Tide plan, from a public health perspective. I mean, wouldn't it be the case that there is homogeneity in determining that such shelters could be vectors in a pandemic, or a place where people could be exposed heavily during a pandemic? And so that is a homogeneous concern across any project built pursuant to the Turning the Tide plan. It's not heterogeneous. So that was not done here, correct? There was no thought, because most of us didn't think about pandemics coming down the pike.
No, Your Honor, the pandemic was not front and center at this time. It was not something that was considered. It's in fact not part of the SECRA analysis.
Well, zoning and public policy is one of the 19 factors considered under CEQR, correct?
Correct, Your Honor.
Okay, why doesn't it fit within zoning and public policy?
Well, zoning is considered when there is going to be a change in zoning or there's going to be an impact on zoning. In this case, the shelter is actually an as-of-right project in the area that's zoned. And so the land use as well, which is also part of that analysis, it's consistent with surrounding land uses, which are quite diverse. So you have multifamily housing, you have commercial, you have industrial, you have manufacturing.
Maybe I picked the wrong factor then. Is there a factor that would account for a common public health risk across all the projects that could be built pursuant to the larger plan?
To the extent that public health is considered, that might come up in community facilities. But again, this particular project is not necessary. It's a small project of 200 people. It doesn't have the impact on the community that would require an in-depth community facility analysis under the secret technical manual.
Okay, thank you.
Thank you, Your Honors.
I believe counsel's last statement shows what the problem is here. And why is that if you look at each individual shelter, you're going to look at it and it's not going to be significant enough to fit under the plan or the secret manual to warrant further review. But if you look at the overall decision, that is significant, and that should require secret review. And the perfect example is the public health issue. The shelter was opened and it had to be emptied, and the people...
You allude to that in your brief, but did you make that argument at the trial level?
The pandemic had not occurred, and these events had not occurred at the trial level. So no, they weren't raised, although the lack of health...
It would seem to me that smaller community-based shelter housing is preferable to the big warehouse type of housing where public health concerns and concerns about safety and violence in these huge shelters have been problematic over the years.
Yeah, but it's the exact opposite. The cluster housing is small individual units. The community shelters are large dormitory-like facilities. So when the pandemic struck, they had to move people out of this shelter back into cluster housing because there was, quite frankly, a high incidence of people getting sick and people dying. It's these shelters, there was a fundamental decision, whether it's financial, for whatever reasons, to take them out of these small units, the cluster housing, and move them into these larger community shelters, and that should have had secret review. It's a discretionary determination that as a policy, it was not, it was specific. They did it immediately after they determined it. It was by whom? It was the city making the determination. There was a generic, fundamental decision made without any environmental review.
Thank you.
Thank you.
Vendome versus Clays T. Oldenburg. You may proceed.
May it please the court, my name is Tara Richello of Olshan Frome-Woloski on behalf of Appellant Antonio Von Dome. Based on this court's decision in PMJ Capital Corp. Versus PAF Capital LLC, 98 AD 3rd 429, this court should reverse the trial court's order granting respondents' motion to dismiss, which focused exclusively on the letter of intent, the party's letter of intent, and the lack of a signed.
But the letter of intent envisioned a final writing with all of the terms, and that never happened.
Correct, and that was the case.
So I don't understand why you're here.
That was also the case in PMJ, where the parties anticipated a final signed writing. But
Counsel, just to add to that, in paragraph 12 of that letter of intent, it says that the parties can decide not to execute the final purchase agreement for any reason whatsoever or no reason at all. Where is that the intent to be bound by anything by this letter of intent? Clearly, it indicates that something else has to happen for it to be binding.
the case law PMJ plus other case law from the Court of Appeals Stonehill collectively informs us that looking at the totality of the circumstances to determine the parties of intent, and in those cases, even where the letter of intent or term sheet left that open, left walk-away language available, those cases found that the
Counsel,
conduct...
can you point to similar language in PMJ? 'Cause I didn't see it.
Yes, Your Honor.
I got the case right in front of me.
Sure. Looking at 431, here, based on the negotiation process that resulted in a written document containing all of the agreed-upon terms.
Except that's not the case here. You don't have all the agreed-upon terms.
The parties had drafted and exchanged and agreed upon a final.
And they didn't sign it.
One
You have
side
to
signed it.
sign it.
Looking at all of the circumstances, all of the parties'
Counsel,
indications.
let's look at the circumstances. You have a contract negotiation period that's extended, right? Past the original date, and it ends on September 15th of 2018. There's a good faith offer made, quote unquote, August 15th, a month before, right? But the contract negotiation period ended. The letter of intent died. And what paragraph 12 says, as referenced by my colleagues, is that if there was no purchase agreement executed for any reason whatsoever, or no reason whatsoever, then that was it.
The parties did exchange a purchase agreement that by all accounts was
But it
final
wasn't
except
signed.
for except for the signatures, correct?
Well,
That's the most important part,
right?
Yes.
So there's
And you
no
don't have
purchase
that.
agreement if you don't have the signatures, right?
All of respondents' assurances through their counsel's email, we are moving forward, we will push this forward, we are substantially there.
Counsel, you and I both know that an attorney's assurances, it's looking good, yeah, I think we're a go. It's not done until the document is signed.
At that point, appellant had no reason to believe that the letter of intent with this walkaway language was still in effect, given that the parties were moving forward. He had conducted a walkthrough of the premises. They were finalizing the language. The purchase agreement over the course of a year and a half had been drafted and exchanged, and save for a signature, these parties had reached an agreement. Respondents had gotten the exact consideration that they asked for, and appellant was ready.
The letter of intent had an expiration date which was extended, correct?
Correct.
And that was still in effect at the time this deal fell apart, correct?
Correct. But looking at all of the circumstances, appellant had no reason to believe that respondent would walk away at the last moment.
Except that they didn't sign it and turn it and send it back. That was like the clear telltale sign. But we'll hear you on your rebuttal. Counsel?
Thank you, Your Honors. My name is Kenneth Gobetz. I'm here today to represent the respondent. We believe that the lower court properly dismissed the complaint because the LOI refutes all of the allegations in the complaint. As to the arguments regarding the PMJ case, all of those arguments appear for the first time in the reply brief filed with this court. They are inconsistent with the allegations in the complaint. If you look at paragraphs 18 through 21 of the complaint, it alleges that there was not an agreement between the parties. It alleges that the seller asked for more money and the buyer said no. The seller asked for more money again and the buyer said no, and he said, what about this? And then the complaint alleges that we never heard from the seller again. That is inconsistent with the arguments made for the first time before this court in the reply brief. And with that, Your Honor, unless there are further questions, I would submit our brief.
Thank you.
Thank you, Your Honors.
Counsel?
On the opening brief, the appellant did argue that the letter of intent had amounted to an agreement, which is the fundamental principle that is in PMJ. And so here, what we're asking this court to do is look at all of the circumstances leading up to the exact moment that respondents abandoned the deal. They had exchanged drafts, they had conducted the walkthrough, the terms are set forth in the letter of intent, plus the purchase agreement, such that, except for the signature, they had absolutely reached an agreement. There was a meeting of the minds as to the sale of this property, and appellant was ready and willing to go through with that when respondent went silent on that deal. And I would also offer that in the case law that suggests that a letter of intent is sufficient to show that there is a meeting of the minds. So even without the purchase agreement contemplated in the letter of intent, the parties had substantially agreed to all of the terms that were necessary to complete.
Wasn't one of the terms that the purchase agreement would be mutually prepared and executed by buyer and seller,
Yes.
and it didn't happen.
Other than respond, correct, yes.
Okay, thank you. People versus Joseph Elliott. You may proceed.
Thank you. May it please the court, Marika Meese for appellant Joseph Elliott. I will be focusing on point 3 of my brief, which involves the improper discharge of a sworn juror. In this case, Mr. Islam, who was the juror in question, had gone through all of the phases of jury selection. He had answered all of the questions the judge posed in the questionnaire, and they were all responsive. Then he answered questions posed by both sides in individual attorney voir dire. He was then sworn. Thereafter, court staff alerted the judge that—
Counsel, didn't the court find that this particular juror had difficulty comprehending English and also speaking English? And I did read some of the language, some of his words, and they indicated the pretty basic difficulty with the language.
Judge, that is the basis that the court ruled on, but the record here did not support a discharge for failure
Counsel,
to understand English sufficiently to serve.
Can I talk, please? Can I talk?
Yeah, I'm sorry, it's really hard to hear, so I didn't know you were still speaking.
If you hear little words coming, they're from me.
No, I understand.
Okay, so isn't the court in the best position to determine whether or not somebody can understand the language? The judge is right there. The judge is having a conversation with this person, and the judge can discern from the totality of the situation whether the person is able to understand.
That is true that the trial judge is in the best position, but on this record, what I am trying to demonstrate is that this juror had responded to the entire questionnaire, and all of his responses were accurate to the questions posed.
How do you account then for this juror's misimpression that the trial was going to be just one day?
I think that's a frequent occurrence for first-time jurors. He had indicated he had never served as a juror before.
Except that I've picked juries as a judge too, and one of the first things a judge tells a prospective jury is more or less how many days they think the trial will last. And you need to do that in the process of jury selection because you want to alert the prospective jury panel if somebody has a vacation scheduled that's going to interfere with these next 5 days, we should know that, right? And so he went through all of this jury selection, answered the questions appropriately, as you said, yet he thought the trial was going to be just one day. Doesn't that indicate that he clearly wasn't fully understanding what was being said?
I don't think so, because I think as a first-time juror, that kind of mistake is a frequent occurrence, and the rest of the record demonstrates that he did have sufficient understanding of the English language. And importantly, when the court conducted an inquiry, the juror never said he had a problem with language, and the court never asked the kind of questions that would have elicited information to support that ruling. The court didn't ask, for example, whether he spoke English at home or at his job. The court did not ask how long he had lived in the United States. The court did not ask whether he specifically understood any of the
Is there a formula? Is there really a formula to determine whether or not a person can speak the language or understand the language, or is it rather the experience of interacting with that person that's dispositive here?
There's no formula, but when the juror was brought in for inquiry on the claimed basis of a language issue, that's what court staff alerted the judge to. The judge didn't ask a single question, nor did the juror voice a concern about understanding English. He instead offered other reasons, being the sole breadwinner, planned trip to Bangladesh, and a sick wife, but no inquiry was made of those issues either. So on the record here, there simply wasn't enough to support the court's decision to discharge this juror under any of the standards that might have been appropriate.
Was the defense prohibited from asking questions of this prospective juror by the judge?
You mean during the inquiry?
During the inquiry?
No, both sides, I think, were asked if they wished to pose additional questions, but they did not. But the defense did object to the discharge of the juror, and neither side had ever voiced any concern about the juror's facility with language during the proceedings.
All right, you'll have some time on rebuttal.
Thank you.
Okay. You may proceed.
Good afternoon, Your Honors. May it please the court, my name is Patricia Curran, and I represent the people on this appeal. The trial court providently discharged this juror.
Counsel, before you get into that, what about this issue that the court never asked any questions about whether or not how long he had been in the country, what he did for a living, so assess whether or not he in fact understood the English language efficiently?
There is no requirement, Your Honor, to ask the kinds of questions that the defense counsel is now suggesting might have been required. But I should point out, defense counsel had an opportunity to ask any questions he wanted at the time, but chose not to.
Yes, but it's if here, this issue was brought to the court's attention by a court staff, you don't think that it required the judge to at least do a basic inquiry?
Well, Your Honor, I think that
I mean, I used to get this all the time, and I went through a whole litany with jurors about whether they spoke English or not, how long have you been here, etc. Because sometimes people don't feel comfortable speaking in English because they feel they sound funny or they have an accent, but they understand a heck of a lot.
Well, Your Honor, the fact that other judges may have asked different questions doesn't mean that the questions that this trial judge posed to this juror...
Well, what did he ask?
Well, she talked to him and obviously found out or decided that the court staff was right, that he really didn't speak sufficient English to understand the proceedings, and the record bears that out.
Okay.
Counsel, does it make a difference whether or not there were only, I think, 4 or 5 jurors sworn at the time? Does that matter?
Are you asking me if there were sworn? I'm sorry, it's hard to hear. You're asking
How many jurors were sworn at the time that Mr. Islam was discharged?
He was one of 5 initial jurors who were sworn.
Right, so all the jurors hadn't been sworn, all 12 at that time?
Correct.
Does that matter?
Not under this analysis, no, and I should point out the defense did not preserve the claim that they're arguing now that the 2 statutes require something different, 270.15 subsection 3 and 270.35. This court has in the past looked at these sections and decided that illness and gross disqualification under each statute is the same under each statute. And I should point out, not only did the court find that this particular juror did not speak sufficient English, she also found that he was the sole breadwinner of his family and that his wife was ill and he had a planned trip to Southeast Asia.
Those 2 things are kind of inconsistent to me.
Well, we don't know what...
Unless I doubt seriously he's taking his wife to Bangladesh for treatment rather than here in New York.
Well,
so my wife is sick, but oh, by the way, I'm going to Bangladesh?
Well, Your
Those 2 things don't jive.
Your Honor, we don't know what the wife was ill with, and we don't know when the trip to Bangladesh was, so I'm not sure that...
So then more questions should have been asked by the court?
I don't believe so, Your Honor. This court should defer to the discretion of the trial judge who actually spoke to this juror and was able to assess his demeanor and his ability to speak and understand the language.
But you're not suggesting that we should not probe where we have a record in front of us and perhaps think that there is lacking inquiry, that those are not issues that we should address?
Well, Your Honor, the standard here is whether it was an abuse of discretion. And of course, this court can look at the record and decide whether it's sufficient or not, but we obviously urge this court to find that it is and that other questions and answers were not required here.
Okay.
If there are other questions on this or any of the other points, I'd be glad to answer them. Seeing none, thank you very much.
Thank you. Counsel?
The records indicates that the judge did not do any inquiry of the other subjects raised by this juror, and his raising those other subjects also demonstrated that his understanding of English was more than adequate to serve. While deference can be given to a trial court, the court simply failed to do the kind of probative inquiry that's required under any standard, whether it's the 270-15 subdivision 3 or the grossly unqualified. So here, this record does not support the discharge of this sworn juror. And I would just like to touch briefly on the sentence imposed here for Mr. Elliott, who was in his mid-50s, who had just testified at trial and explained that he had a drug addiction and mental health issues. And he was convicted of possessing a small amount of drugs for personal use. Yet the court imposed a more than minimum sentence as to each conviction. And on the bail jumping, Mr. Elliott explained that he had left to take care of his elderly, sick mother in North Carolina, and he had provided contact information for his whereabouts. So on that record, the sentence imposed here of more than the minimum and consecutive was excessive, and I'd ask this court to reduce the sentence.
Thank you.
Thank you.
Shuttle Cloud Corp. versus New York State Department of Taxation and Finance. No, isn't this the next one?
We missed one.
Did I miss one? I'm so sorry. People versus Eugene Graham. My apologies. You may proceed.
Thank you, Your Honor. My name is Tim Grinsell with Hallwell, Schuster, and Goldberg and the Office of the Appellate Defender on behalf of Mr. Graham. May it please the court. Mr. Graham's lawyer, Harvey Slovis, failed to prepare Mr. Graham's case, was faced with the threat of removal, and seized on Mr. Graham's alibi defense as a lifeline to avoid professional sanction. Simply put, Mr. Slovis pursued the alibi defense to save Slovis's skin, not Graham's. When the court tried to inform Mr. Graham of the risks involved in this conflict, Mr. Slovis stonewalled the court and steamrolled his client. The inquiry failed, and reversal is required.
Wasn't there a second attorney that was appointed?
Yes, Your Honor, but the appointment of an additional attorney after the pretrial hearings in which the Gomberg inquiry was held could not cure the fundamental conflict of the lead attorney, who indeed ended up controlling the course of Mr. Graham's defense throughout the entire proceedings.
Counsel, wasn't the defendant questioned extensively and cautioned extensively with respect to his choice to retain Mr. Slovis as counsel?
The questioning as to whether or not Mr. Graham was informed of the risks of Mr. Slovis's conflicted representation failed for three reasons. First, Mr. Slovis stonewalled the court. The best example of this is the following line of questioning. The court asked Mr. Slovis, "You are not allowing your client the Gomberg inquiry?" Mr. Slovis's response, "No." Second, Mr. Slovis conditioned Mr. Graham's participation in the Gomberg inquiry on a favorable ruling on the alibi defense. Keep in mind that as a result of his complete failure to prepare Mr. Graham's defense, the court threatened Mr. Slovis with removal, and the prosecution moved to remove Mr. Slovis as a result of his ineffectiveness. And Mr. Slovis consulted the First Department's disciplinary committee, who told him the following: if the alibi defense comes in, you're okay. If the alibi defense is precluded, you have a big problem. Mr. Slovis grabbed on to Mr. Graham's alibi defense as a lifeline to avoid the threat of professional sanction, to avoid the threats to his professional reputation and his credibility, as Justice Fabrizio found below, and indeed to preserve the opportunity to earn additional income as a member of the 18B panel going forward. Simply put, Mr. Graham never had the type of unconflicted, impartial assessment of his alibi defense that he is entitled to under the law. In addition, Mr. Slovis steamrolled his client during the questioning about Mr. Slovis's conflict. Mr. Slovis first advised Mr. Graham to remain silent in the face of the court's questioning. Mr. Slovis also told Mr. Graham he didn't have enough information to answer the court's question. And this includes questions about whether Mr. Graham would like to consult an additional attorney with respect to Mr. Slovis's conflicted representation. So, for example, when Mr. Graham was asked whether he would like to consult an additional attorney about Mr. Slovis's continued representation, Mr. Slovis said, quote, "He is not going to answer that question because I am waiting on a ruling from you." Third, Mr. Slovis puffed himself up in front of Mr. Graham to imply that any lawyer Mr. Graham received that would replace Mr. Slovis would be a worse lawyer. And the final reason the Gomberg inquiry completely failed is because the risks, the relevant risks, were not explained to Mr. Graham. Mr. Graham was never explained how Mr. Slovis had a personal investment in putting on this particular alibi defense. In addition, the court did not explain the nature of the ramifications of those risks, including the fact that the risk of the alibi, the risk that the alibi defense could blow up, the risk that the alibi defense would implicate Mr. Slovis's own conduct. And in fact, at trial, the prosecution asked one of the alibi witnesses over 50 questions about her attempt to contact Mr. Slovis when she came forward, how she tried to either call or email him. And Mr. Slovis is the only one who could have corroborated some of those facts. And the court certainly never explained the attorney-witness rule, which would prevent Mr. Slovis from testifying to corroborate anything the alibi witnesses said. If there are no further questions, I will address the remainder of my points on rebuttal.
Thank you.
Robert Myers for the Office of Darcel Clark. Good afternoon, and may it please the court. I do have 5 points that track with my brief, but I'll just jump into point 1, which is that defendant received effective assistance of counsel. First, he identifies no
Alibi
prejudice.
defense is probably one of the worst defenses that any criminal defense attorney can assert, especially if every single alibi witness is a family member. So I'm not so sure that your first point is accurate.
And yes, Your Honor, defense counsel here was locked into an alibi defense, given defendant's statement to police the night of his arrest that he was at home, he'd gone out, smoked a little weed in the hallway, and gone to bed. So from the very beginning, on February 13th, that was his statement given at the police precinct.
Yes, and that's a statement that would not come in unless he testified, right?
And that's correct.
So that he wasn't locked into an alibi defense unless he testified or unless the alibi defense was asserted.
And yes, Your Honor, you're correct again that he was not locked in, but that was defendant's answer in his statement there, and that was the only defense available. There's no indication that there was any other defense that defense counsel could have put forward in this situation here. Defense counsel did render meaningful assistance here, and again, defense counsel did not, or defendant did not.
Was there an eyewitness to the shooting?
And there was an eyewitness on the stairs. Mr.
Who
Alton.
saw the actual shooting?
He did not see the actual shooting, Your
Okay,
Honor,
so
no.
there was no eyewitness to the actual shooting, correct?
Correct.
Everything else was circumstantial evidence.
Correct.
I've seen cases tried on less.
And yes, Your Honor, and this case was tried.
Right.
And defendant was convicted by the jury who heard the testimony from Mr. Alston that he saw the defendant with a black object that appeared to be a gun in his hand, heard the gunshot, and then his friend, the deceased, Mr. Green, was killed by that gunshot. So there was clear evidence, and the court did give a circumstantial evidence charge to the jury as well here. Yes. And the jury, after hearing that, hearing the testimony, did convict the defendant. But I do also just want to note, again, the prejudice point. I do want to just kind of emphasize here that this court should be skeptical of claims regarding ineffective assistance of counsel where there's no prejudice here. Here, although defense counsel Mr. Slovis did not timely file alibi notice, he put forward a full alibi defense. He called 3 witnesses who testified that defendant had remained in his bedroom on the night of the shooting.
Yeah, his mother, his aunt. I mean, again, alibi defense it flies if it's your neighborhood priest who saw you. But when it's your mother saying, no, my son didn't do that, he was home the whole night. I haven't seen that defense work once.
Also, counsel, there's the background of the counsel not meeting with the client after appointment. He met with him only on March 31st, 2014. This is by his own admission, and on November 5th, 2014, after he was appointed in February 2012. So there's that background. There's this feeling of desperation here that you know, I'm not sure what we can do with that.
And, Your Honor, there were a number of instances where defense counsel did not waive defendant's appearance and where defendant did appear in court alongside defense counsel and would have had the opportunity then to discuss his possible defenses.
Counsel, really? 2 seconds during a calendar call? You think that's effective assistance of counsel?
And, Your Honor,
On
again,
a murder case where this young man is looking at this kind of life sentence? He doesn't talk to his client in 2.5 years from arraignment? That's effective assistance of counsel?
yes, Your Honor. Given that he received a meaningful defense here, there were a number of there were motions that were filed here, successful cross-examination where he impeached the people's witnesses. He filed a CBL 330 motion. He provided meaningful assistance and put forth the alibi defense. He actually prejudiced the people using his tactic, which he admitted was his usual standard practice of not providing alibi notice until shortly before trial. So the people were not able to conduct a full, more thorough counter-investigation to look into the whereabouts of those family members, to investigate workplace schedules, for instance, for night shifts, or to conduct a neighborhood canvass to investigate. So I see my time has concluded, and if there are no further questions, I ask this court to please affirm.
Thank you so much. Counsel?
My colleague concentrated on the prejudice point here, but prejudice is not required to find an ineffective assistance of counsel claim to be valid in the context of a conflict of interest. And here, respondent has put forth no argument suggesting that there was no conflict of interest. If there is a conflict of interest, or even a significant possibility of a conflict of interest, a Gomberg hearing is required. It is reversible error if the Gomberg hearing either is not held or if it is inadequate to meet the requirements of fully informing the defendant of the risks involved in proceeding with conflicted counsel and spelling out the ramifications of those risks. To your point, Your Honor, it is true that Mr. Slovis's ineffectiveness was spilled out on the record over 5 days of pretrial hearings. But it is also true that a defendant like my client would not have the legal sophistication to understand, as Your Honor pointed out, how risky an alibi defense could be. The risk that the alibi defense could blow up, the risks that the first questions the alibi witnesses will be asked are, when did you come forward and who did you try to talk to? Risks that manifested in this case, no fewer than 50 times when the prosecution questioned one of the alibi witnesses. And the conflict that Mr. Slovis enacted by pursuing this alibi defense under the threat of professional sanction completely deprived Mr. Graham of the unbiased assessment of the menu of options he may have had for his defense in this murder case. Quite simply, Mr. Graham never received the unconflicted assessment of his options of the defense he was entitled to. And that is ineffective assistance of counsel regardless of any prejudice that may or may not accrue. Now, it is absolutely...
Will you address your adversary's argument that this was the only defense available to your client?
Yes, may I?
Yes.
This is not the only defense available to my client. I respectfully disagree because Mr. Graham always had the defense of putting the prosecution to their proof. As you point out, Your Honor, it is not the case that there was a eyewitness to this crime. It is the case that the victim's brother did not identify my client in a identification lineup shortly after the crime. And it is also the case that the 2 witnesses that the prosecution put on the stand, fact witnesses, were impeached multiple times on almost every aspect of their testimony, such that a competent attorney could have achieved a different result for Mr. Graham. Thank you.
And now, Shuttle Corp versus New York State Department of Finance and Taxation and Finance. You may proceed.
May it please the court, Richard Zemsky for Plaintiff Appellant, Shuttle Cloud Corporation. In this case, the lower court failed to apply the correct standard of review on motions to dismiss, leading to decisions on both mootness and exhaustion that were predicated on facts solely as espoused by respondents, despite contrary evidence and facts provided by appellant, who was the non-moving party on those motions to dismiss. So first, as to mootness, appellant was not paid the amount that it sought in the complaint. The trial court, instead of getting into the actual calculation of interest on excess MFI, the mandatory first installment that's embodied in the tax code, the trial court said, I'm not doing math for you guys. Yet there were two critical errors in that interest calculation, and the case can't be mooted when the plaintiff hasn't been made whole. One of those errors related to the principal amount in the interest calculation. So for MFI, the mandatory first installment, I'm just going to keep using the abbreviation for succinctness, but for MFI, it can be satisfied in two ways by a corporate taxpayer. First, it can make a discrete payment for its MFI, and second, it can apply a previous overpayment. So if you previously overpaid your tax and you have that on credit, you can apply that to your MFI. And you can do both of those together. You can have your overpayment plus your discrete MFI amount. So both sets of respondents in this case only did their interest calculation based on a discrete payment, and they failed to do it based on the overpayment plus the applied credit from the previous overpayment plus
counsel,
MFI.
I know that at one point, the appellant claimed that he was owed $7 on one thing and $1 on the other, right?
So there are two sets of defendants.
And I know that at another point, there was a refund afforded to him and he rejected it. So my question to you is kind of a math one, which is to say, how much was refunded or offered to be refunded to him, and just how much is he claiming that he's owed?
Sure. So it wasn't that we rejected the refund. We rejected these proffered payments after the filing of the lawsuit. And so the specific amounts, I'll use tax year 2015 because that's the most relevant, although there are a couple of years at issue. So for 2015, for example, for New York City, they took the MFI amount as a discrete payment of $1,285, but ignored the $12,000 carry forward, which is almost 10 times more.
You have to make this simple. Just answer my question, because the math calculations are atrocious. So just make it simple. How much was proffered or paid to him, and how much does he say he's owed?
Right, so the amount proffered in 2015 by the city was, the interest portion was $1,373.69. They did pay a larger sum, but they also threw in a refund amount that wasn't even at issue here. So the interest portion was $1,373.69.
So he's not owed anything for that year?
Excuse me?
So they gave him too much money, you say he's not owed anything for that year. How much money are we talking about? He claims and if he had an issue, did he go before any administrative body to challenge the amounts?
Sure, so the interest through 2020 at the time of this payment for New York City should have been about $3,336, not the $1,300 and change.
Okay.
And the reason for not going in front of an administrative body, and this gets to exhaustion of remedies.
Please.
What's really telling here, after the filing of this lawsuit, and only after the filing of this lawsuit, the state respondents adopted a procedure to request MFI, excess MFI payments, and the interest on those payments. No such procedure existed prior to the filing of this lawsuit, which tells us two things. One, there was no procedure, and relatedly, any other types of refund procedures did not cover MFI and the interest on MFI, because otherwise, why would they then adopt this new procedure? So there was no procedure, and because there's no procedure to request this, you can't get a statutory notice from the administrative agency. That's the key instrument for jurisdiction in the administrative forum. So without the statutory notice, there's no way to proceed administratively.
Okay, you'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors. May it please the court, Linda Fang on behalf of the state respondents. This court should affirm the dismissal of the complaint because the doctrine of administrative exhaustion bars plaintiff's claim for interest, and as Supreme Court properly concluded, its constitutional claims are meritless.
Counsel, you're picking up the thread that your opponent just finished on, which is administrative exhaustion. Wasn't it the case that you could, for some time, grieve disputes over interest concerning the MFI?
Absolutely. There's always been robust procedures under state law. State law and regulations we cited extensively in our briefs. There is available administrative and revenue avenues for taxpayers to ask for interest. And I just would like to point out, there's no question here that plaintiff did not ever request this interest from the State Department before bringing this lawsuit, many years after it stopped doing business in the state and several years after it paid and it was entitled for this interest to be returned to it. And the whole argument about administrative exhaustion, I think the questions about mootness and Your Honor's questions about how much is at dispute here, there has been no answer. And I think it's not the business, and that is the reason that illustrates why administrative exhaustion is the rule, because there should be the opportunity, the legislator has provided the exclusive remedy for taxpayers to first ask for the request, to ask for the money back. And here we are talking about $8 of interest on a $408 overpayment that was made over 6 years ago by this taxpayer, which no longer does business in the state. Never pursued any administrative remedies in state court. We have published third department decision that addresses interest-only claims. We have a published decision from this court that Justice Mazzarella was on.
What exactly was the administrative remedies available to taxpayers? Because your adversary said that procedure was only recently established. Is that true?
That is absolutely not true, Your Honor. I think he's alluding to the fact that after this lawsuit was filed, the state put on its website, in order to make this request for interest, please write a letter and here's our address. That procedure was always a procedure. Okay. The fact that it wasn't put on the state's website that maybe you should make a written request for this particular interest, for this particular taxpayer, which is the only proper party before this court, before you commence a declaratory judgment in Supreme Court 3 years later, I don't think that's a new procedure.
So counsel, which is the entity? Sorry.
Go ahead.
Which is the entity? Is it the Division of Tax Appeal? Is it the Tax Appeal Tribunal? Which is the entity that should have heard this?
Well, first, they should have made a request to the tax department for the interest. Then, if the tax department didn't respond, there's a statutory remedy that if nothing is responded to in 6 months, they can take basically a petition to the Tax Appeals Tribunal. I get the names mixed up a little bit. You can ultimately go to the Tax Appeals Tribunal. That's the second level review. And then after that, the legislature provided you go to the third department. And that's where these types of cases are heard.
So if I have paid an MFI based on what I believe my estimated tax will be, and my income is less, so that I would be due a refund because I paid too much, I have to send a letter saying, I think I paid too much, and this is how much I think I paid, by how much. I have to wait 6 months for the state to answer?
No, you don't have, can I have leave to answer your question? You do not have to wait 6 months for the state to answer. I'm pointing out that they're claiming that the state doesn't respond to this. Okay. And I'm saying they can always proceed to petition before they receive a response.
Okay.
But after 6 months, it's deemed denied, so they can also separately petition to the tax appeals and go through the administrative remedies. And again, we never even had a request in the first place. The underlying overpayment amount was refunded to them in 2016 by the state. I know there are separate claims against the city, and I'll let my city colleague respond. Thank you very much.
Thank you. Counsel for the city?
Good afternoon, Your Honors.
Good afternoon.
Kevin Harkins for the city. I just want to address how the procedures for the city and the state differ. So in this case, when a taxpayer files their tax return and they request a refund, if there's no response within 6 months, then pursuant to the administrative code, the refund claim is deemed denied. At that point, pursuant to Administrative Code 11680, you are free to file a petition with the New York City Tax Appeals Tribunal.
Is this aspect of if you don't hear an answer from us in 6 months, you should deem it denied, is that on the website? How does the public know? If I send a letter, where can I read that you have up to 6 months to respond, and if I don't get a letter in 6 months, I should assume it was denied? Where can I find that?
So right off the bat, this is a difference between the city and the state. You don't have to send any letter.
Okay.
All you do is file your tax return.
Right.
If you're due a refund, if you don't get that refund in 6 months, then it's been deemed denied. And the reason that's significant is because, as counsel is alluding to, in order to file a petition with the New York City Tax Appeals Tribunal, you need some jurisdictional document. But if the Department of Finance never gets back to you at all, then they're not going to issue any document. And so that's why the 6-month cutoff allows someone to then go to the Tax Appeals Tribunal, and they don't have to wait for that jurisdictional document to be issued. So it's just a way to keep the process moving along.
But my question was, how does the public know that?
Well, it's in the administrative code. I don't believe it's on anyone's website.
Most people I know don't read the administrative code. So if I, as a taxpayer, am looking up on the website, does something tell me at 6 months, if you haven't gotten your money, you should file an appeal?
Well, maybe for the average taxpayer, Your Honor, that would be a valid point, but with counsel, I would think they could look this up and read this themselves. Additionally, he talks about mootness, and this is really significant as well, because when the complaint was filed, the department searched their records, realized this tax refund was never issued, and promptly issued a check. They rejected that check, saying it wasn't the right amount. They've never said what the right amount should have been, what did they think it was, whatever. Only in their reply papers in this court do they finally say what they think the actual MFI number should be, and this explains the whole problem. Remember, MFI is defined by statute. It's 25% of your preceding year's tax liability. That's it. And if Your Honors will look at record page 95, lines 10 and 11. Line 10 is your tax liability. Line 11 is your MFI number. It specifically says 25% of your tax liability. And if you look in this case, record page 95, the tax liability was $5,100. I'm rounding up the numbers. The MFI, 25% of that is $1,285. That's the MFI. It's right on the form. It's defined by statute. What happened here, for whatever reason, they had a tax bill of $5,100, but they prepaid their taxes $61,000. Okay? And that led to a refund of $42,800 and a $12,000 carry forward credit to the next year. And that's what they want to say, Your Honor. They want to take MFI and this carry forward credit, add it all together, and say that's MFI. They're redefining the statute. That's the whole case. And they never said it until the reply papers, and that's why you have to exhaust administrative remedies. We shouldn't be standing here looking over tax returns trying to figure out the numbers. It should have been done below. And for that reason, I ask that the court affirm the lower court.
Thank you so much.
Thank you, Your Honor.
You may proceed.
Thank you. So first, I would just point out that counsel for the city is wrong. We actually fully briefed the formulas and the numbers for calculation of the interest on MFI for the lower court, and indeed attempted to raise it, at the oral argument, and were cut off by the trial court. That said, in the record, we did put...
But how does that change the fact that you have never sent a letter saying, you sent me a refund of this, what you actually owe me is that? You never did that.
That's right. So that procedure never existed for...
What procedure? If you receive a check and you think the check number is wrong, it's simple. Send a letter and you say, this is the wrong amount. The right amount is XYZ, And I believe that's the right number because A, B, and C. How difficult is this?
No, I understand that. So one point of clarity, we only received those checks after we filed this lawsuit, right? It was an attempt to moot the case, but they actually paid the wrong amount. They didn't do a good job of mooting it. Prior to, there's a whole history, and we provided evidence by way of an affidavit for the trial court, and in the record here, that other corporate taxpayers for years tried to get the interest on their excess MFI payments, and they were not even able to get into the administrative forum because they wrote those letters, in some instances contacting the tax authorities 11 different times, and they never got the key statutory notice or jurisdictional document that confers jurisdiction on the administrative courts. Now, counsel for respondents point to two cases in their brief trying to show that the administrative forum exists for interest-only cases, both McNulty and Goldstein, and there is a key, very key factual difference in both of those. Those cases all had statutory notices, notices of disallowance, and they had concomitant claims for refund, which ultimately were resolved, and then what was left was the interest claim, but they started off with refund claims. And if I were to just to very briefly quote, the notice—
No, don't do that. You've given us the cases because you're out of time. Okay, thank you.
Your Honor.
We've got your briefs. Lou versus Ruiz. You may proceed.
Good afternoon, Your Honors. Renee Cathawala from Orrick, Arrington, Sutcliffe for the appellant, Ms. Liu. The timing requirement in Section 439E of the Family Court is a critically important and chronic issue in the Family Court. The reason it is highlighted by Ms. Liu's case here. The support magistrate in her underlying child support case got it plainly wrong. The father was in willful violation of the underlying child support order. Unfortunately, the only way that some non-custodial parents pay support is under the threat of incarceration. Mr. Langone, the father in this case, is one such family court litigant. So Ms. Liu was looking at a objection that she filed to what we considered to be a frivolous underlying family court decision. She's waiting. The statute is very clear. It says the family court judge shall decide the objections within 15 days, in short. This court has made very clear, going back to City of New York versus Novello, shall in a statute means shall. It is mandatory. And this court has enforced that principle in numerous range of statutes, including those affecting the judiciary. So the trial judge says, you got your relief. The problem with that is Ms. Liu had filed prior objections in her first violation petition. She was now on her second violation petition. She probably has more. So this is a classic case where the mootness exception applies. And the factors there are clearly met here, we believe. The question is whether this issue is likely to be repeated. What's astounding is the respondent here is arguing that this statute isn't even mandatory. So of course it's going to be repeated because the respondent doesn't believe there's a mandatory obligation for judges in the family court to decide objections within 15 days. So we satisfy prong one of the mootness exception. Yes.
Counsel, we're not talking about a situation where, for example, because of too many cases, the decision was rendered in 30 days or in 31 days. We're talking about a hiatus of how many years?
I'm sorry?
We're talking about a hiatus of how many years here?
Well, I mean, one of the Ms. Liu's underlying child support violation, the first one, it took 9 years to resolve. This one was quicker, but it still took about 9 to 12 months of time to resolve. I just, in response to that question, Justice, the respondent is relying on a class action case that I brought that was up here and is now before the Court of Appeal on a pending motion for leave. The question in that case, Martinez versus Di Fiore, is whether the family court rule
that governs the timing in violation cases is there a cause of action to compel administrators across the board to comply with it. We believe this court got it wrong. We've argued that to the Court of Appeals. There's discretionary language in that family court rule that is completely distinguishable from this. This statute is abundantly clear, and the legislative history, as we put into our brief, makes clear there are a staggering number of child support arrears outstanding. In the Martinez case, it's a public record in this court with the filing there, there's $8 billion of uncollected child support in New York State. There are multiple reasons for that, but certainly one reason is the lack of enforcement of rules like this in the family court. So, so I think the two other prongs of mootness typically evades review. Again, they're saying it's not mandatory, so of course it's going to typically evade review. And frankly, I'm pro bono counsel. I can bring a case like this. The vast majority of custodial parents in family court have no resources. The reason they're in family court is to get some basic resources so that they can feed and clothe and house their children. Of course, it's going to typically evade review, and they know that. It raises substantial and novel questions. Well, certainly they're making a novel question out of this issue because they're arguing somehow that this statute, which is clear on its face, is not mandatory. That it's really sort of mind-boggling that that argument can be made by the chief administrative judge of the city of New York. With respect to attorney fees, this court in 2013 held unequivocally in a very thorough, well-reasoned decision, Sola versus Berlin, that under the New York Equal Access to Justice Act, a prevailing party can be one that is the catalyst for the underlying objective sought. Here, there's no question, even the trial court found that Ms. Liu's lawsuit brought about the decision on the objections that she was desperately waiting for. There's no doubt she's the catalyst, and notwithstanding all of the smoke that the respondent throws up about SOLA, it hasn't been abrogated. That's false, as they claim in their brief. It's still good law in this department. Unfortunately, the second, third, and fourth departments have gone the other way. However, if you read those decisions, they don't address any of the analysis that this department thoroughly considered in reaching the conclusion that, unlike the federal counterpart, the New York Equal Access to Justice Act does allow a litigant like Ms. Liu to collect attorney fees, whereas in this case, she's the catalyst.
Thank you. Counsel? You may proceed.
Good afternoon, Your Honors. Grace Sau for the respondent, Judge Ruiz. In the midst of the pandemic, the petitioner filed this Article 78 proceeding to compel family court to immediately rule on her then pending objections. Supreme Court properly dismissed this proceeding as moot and correctly denied her request for fees after family court issued a decision just a few weeks later. I'll first quickly address
How long had it been pending, the objections, before the pandemic hit?
The objections were fully briefed at the end of November, Your Honor, and a decision was rendered on January 19th. So it's not.
Which means that since the pandemic had not hit, right, it should have been decided in a timely fashion.
When the objections were filed, Your Honor, it was already during the midst of the pandemic.
Okay.
And at that time, the courts were instructed to limit their operations to essential matters, of which support proceedings were not one. And
really?
That's correct, Your Honor. Under the Chief Judge's administrative orders, he required that courts limit their proceedings to essential matters as the courts may allow, and a later administrative order listed essential matters.
Did you make this essential argument at the trial level? The argument that you're saying that support matters were deemed not essential. Did you make that argument below?
We did, Your Honor. We made this at pages 7 to 8 of our motion or memorandum of law. It's not in the record, Your Honor, but it's at NICEF number 17. We did make this argument that the petitioner does not have a clear legal right to compel the family court administrator to prioritize her case over others during the pandemic.
Except that until a judge is assigned to her case, then her objections can't be heard. So how is it that a statute that says objections must be decided within 15 days, somehow the system thinks that they can get around that rule and not abide by the law by simply not assigning a judge.
So
How can that be right?
Your Honor, in this case, during the pandemic, the governor's executive orders told procedural
But the
deadlines.
objections were filed months before the pandemic. What was the delay?
Your Honor, the objections were not filed before the pandemic. Instead, they were filed in October of 2020, after the pandemic had already commenced.
But it is true, counsel, that the petition was filed in December of 2012, and the petition wasn't decided until November of 2019, right?
So the issue here, Your Honor, is the delay in ruling on the objections. It does not have to do with any decision on the underlying petition. What petitioner is arguing is that because a decision on her objections was not rendered within the 15-day time limit, that she was entitled to file a petition for writ of mandamus to compel the family court to immediately rule on her objections. And in this case, what we're saying is that at the time her writ of mandamus was filed, that the 15-day deadline was not in effect. The governor's executive orders told procedural deadlines, including the 15-day limit under the Family Court Act. Moreover, the chief administrative judge at the time also issued a series of administrative orders which required courts to prioritize essential matters, which did not include petitioner's objections. It's also important to note, Your Honor, that for the issue of fees, the standard is whether the state was substantially justified, which does not require this court to conclude that the state was absolutely correct, but whether the state's position had a reasonable basis in law and fact. And here, in light of the circumstances of the pandemic, in light of this discretion that was afforded to courts and court administrators in managing their dockets during the pandemic, and in light of the fact that the executive order meant that the 15-day deadline that petitioner seeks to enforce was not even in effect at the time, Judge Ruiz's management of the family court docket was substantially justified here. Your Honor, if you agree that the state's position was substantially justified, petitioner is not entitled to fees, and you need not reach the issue of whether she is a prevailing party under the state equal access to justice.
There can be no question that she's a prevailing party, right?
Respectfully, Your Honor, we would disagree. Even under the catalyst theory, petitioner is not a prevailing party because cases applying the catalyst theory require not only a petitioner show that her lawsuit caused the state's change in position, but that it was the merits of her lawsuit that did so, and not any other factors such as expense or nuisance.
Well, I think she's got that too.
Your Honor,
I mean, for how long does this father get to not pay child support for a special needs child before somebody actually does something about it?
Respectfully, Your Honor, there's nothing in the record that shows that the merits of her mandamus claim, which seeks an extraordinary form of relief, compelled the state to act in any manner. In fact, for the reasons that we were discussing.
Just coincidence.
Your Honor,
just coincidence that she files the mandamus and then finally somebody acts. That's by coincidence.
Your Honor, it may be that the pressure of the lawsuit caused the state to act, but the standard, the applicable standard, requires petitioner to show that it in fact is the merits of her lawsuit that compelled the state to act and not the burden of the lawsuit, which was filed during COVID, or the expense of the lawsuit. And here we're saying that the merits of the mandamus claim simply, it's not meritorious, and therefore it could not have motivated the state to act because of the petitioner's likely threat of legal victory. And that's the standard that petitioner has to satisfy here in order to show that she is a prevailing party, even under the catalyst theory.
Counsel, I'm just looking at the dates as usual, and you have the objections served in November, the father's rebuttal served in November, there's no judge assigned as of December. You have the Article 78 filed in December, and then finally there's a judge assigned in January. How can you not say that the mother here is the prevailing party? Isn't the traditional definition of prevailing party expanded by SOLA? Isn't this like a classic catalyst theory case?
So, Your Honor, in our papers, we take the position that this court should not adopt the catalyst theory, but even under the catalyst theory, it still requires the petitioner to show that it's the strength of her claim or the merits of her claim, and not just simply the pressure of the lawsuit, the nuisance of the lawsuit, or the expense of litigating the lawsuit that caused the state's change in position. And here, because the mandamus claim lacks merit for the reasons that we had discussed, she is not a prevailing party even under the catalyst theory.
Okay.
Thank you, Your Honors.
Your Honor, briefly, Justice Moulton asked the question about whether essential matters argument was waived. It was waived. The counsel read from a brief. They didn't talk about essential matters. They said Justice Ruiz had discretion to decide what to do. That has nothing to do with essential matters as they're framing it before this court. The argument was waived. And in fact, if you look at page 132 of the record, there's a protocol that Justice Ruiz issued during the pandemic, and I will, just so we can be clear, this did occur during the pandemic. And I'll get to, if I'm allowed, just, I think it's important to look at the executive order. But there was a protocol that said support magistrates may hear child support cases during the pandemic at that time, October 2020, when this case was tried, where counsel was representing the clients. First of all, I think it's crazy that the family court shut off access to child support for unrepresented litigants. That, to me, is mystifying. But the respondent's own administrative order said very clearly that this support magistrate had authority to conduct this hearing because both parties were represented by counsel. The support magistrate conducted the hearing, and he issued his decision. The reason, again, it's so important is because Judge Pels, who's an excellent judge, ruled very clearly, and it goes to the question of why Ms. Liu is the prevailing party. She won clearly because there was a catalyst. This is a clear catalyst case, as Your Honor recognized. She got the result she should have gotten after the trial before the support magistrate. On the question is, let me just discuss quickly, if I may, the executive order, because this seems to be the only plausible argument they have, and it's frankly doesn't carry any weight. The executive order says, quote, any specific time limit for the commencement, filing, or service. So those are the three words to look at: commencement, filing, or service of any legal action, notice, motion, or other process or proceeding as prescribed by the procedural laws, including the family court, is told. The whole purpose of Governor Cuomo's executive order was to ensure the safety of people in the court system. They didn't want people rushing in to file matters and congest the court system. So they said, if you have a statute of limitations issue or whatever, you don't need to come. Obviously, a judge like Judge Pels, who got the decision, can write her decision on the objections from home, from her chambers, in a safe place where no members of the public are present. So that argument this is their principal argument for why Judge Ruiz is substantially justified here, is completely belied by the plain language of the executive order. And of course, the executive order has to be read according to the plain language of the order. So for all of those reasons, we would ask the court to reverse the trial court, to enter an order, and this is critical from an advocacy perspective for litigants in the family court, to enter a clear order that 439E is a mandatory obligation and that the matter be remanded back to the trial court for a determination of the reasonable fees Ms. Liu is entitled to. Thank you.
Thank you. People versus Jimenez Gomez. You may proceed.
Good afternoon, Your Honors. May it please the Court. Anjali Pathpanathan on behalf of Mr. Jimenez Gomez. In this case, the trial court erred in denying Mr. Jimenez Gomez's 3030 motion to dismiss without a hearing, where the prosecution exceeded its statutorily permissible time. There are essentially two types of delays, dispositive delays, over 5 time periods that should have been charged to the people. The first was the people's erroneous reliance on the exceptional circumstances exclusion under CPL 3034G. The people should have been charged 31 days, an additional 31 days, because on 2 occasions, they were not ready to proceed because their witnesses were out of the country. While the prosecution relied on this exceptional circumstances exclusion to exclude the delays, the exclusion actually requires a 2-pronged test, which it never asserted. The first is the one that the prosecution alleged, that there were reasonable grounds to believe that the witnesses will become available in a reasonable period of time. But the second prong, which is also required for this excuse to be called upon, is that the people exercise due diligence to obtain the witnesses for trial. And here the prosecution failed to meet that second prong. They failed to even articulate or address it in their motion papers in response to the defense's motion to dismiss. And so there was nothing that justified the lower court to apply the 3034G exclusion to those 31 days.
Well, there's a difference between the two adjournments, right? The one that happened in October and then the one that happened in May 4th in terms of the unavailability of the witness. At one point, the witness extended a vacation, and at the other point, the witness just was not, didn't even inform, right, that they were going to be out of the country.
Certainly, Your Honor, but the crucial point is that in both situations, the prosecutor's office was not aware that their witness was out of the country until the eve of the trial date. Even for the witness that extended her trip, the prosecutor said on the record that she learned the night before that the witness had extended her
But she was expected to be back, and when she extended the trip, she was expected to be back. The prosecutor had done the due diligence, right?
No, Your Honor. What the prosecutor did was explain that there were reasonable grounds for the witness to be returning in a reasonable period of time. But the prosecutor didn't offer any diligence to assert, for example, something like, we urged her to come back sooner. We told her she couldn't extend her trip. We provided her with means in order to get a ticket faster. These are the examples of where the prosecutor is allowed to use the 3034G exclusion for when a witness travels out of the country unexpectedly and can't return on time. Here, the prosecutor didn't assert any of that. They didn't show their unquestionable documentary proof of any diligence whatsoever to bring those witnesses back for trial.
So you're saying they had to prove, they had to at least assert that they offered the person who was out of the country to pay for their trip back?
They have to at least assert that they did something to get this witness back to trial. In the case that this court found in People v. Ricard, it was very analogous situations where the prosecutor's office knew a witness was going to be traveling out of the country and yet did not, or excuse me, traveling away from the jurisdiction. I don't know where that witness went, but the prosecutor's office did nothing to ensure the witness would be back in time, and that's the due diligence prong.
But the witness said that they would be back in time, and then the night before said, hey, guess what? I decided to stay longer.
Certainly, but the prosecutor's office never explained what diligence they did to ensure that could happen. The prosecutors didn't even suggest that they knew in advance that the witness had scheduled to extend their trip. We have all the
But that's what I'm saying. So you're saying, okay, so in this case, the prosecutor wasn't ready on May 4th because they were notified the night before that they were going to be extending their trip. So are you suggesting that if my witness tells me I'm going to be in France until May 1st, that I have to be checking April 29th, April 30th, you still coming back May 1st? Or is the prosecutor entitled to rely on the communications by a witness? I am going away on this trip, but my date to return is X.
The prosecution is entitled to rely on that as a reasonable grounds for their return, but that doesn't provide any proof that they did any diligence to bring the witness back by date X or before date X. And what is really important here, Your Honor, is if there's a factual question of what diligence was done, what the prosecutor did say to this witness after she found out on the eve of trial that the complainant was not returning, that should have been litigated at a hearing, which is what defense counsel requested. Because clearly what we're having is a factual dispute about what diligence took place or did not take place between the prosecutor and her witnesses who went out of the country.
And what do you say the case law requires in terms of diligence?
The case law requires a credible, vigorous activity to bring your witnesses to trial, and they just didn't assert any. There's nothing in the record or in the motions of the prosecutor herself asserting any activity. All she did was report the location of where her witness was. And if Your Honors look back at People v. Ricard, which is this court's case, it's pretty much the same situation where a witness went out of the country. The prosecutor's office has to provide diligent proof that they exercise credible and vigorous activity to bring their witness to trial. And so what we have here is just a prong that was not answered to. So if Your Honors find that there isn't facts to support the diligence or non-diligence, what is required is that this case is remitted for a 30-30 hearing below.
Thank you.
Thank you.
Ajoku versus New York State Office of Temporary and Disability Assistance. You may proceed.
Good afternoon. May it please the court. My name is William Coles. I represent Appellant Ajoku. This is an employment discrimination and whistleblower case. Mr. Ajoku worked for the state of New York. He was terminated in 2018 from his employment due to blowing the whistle on time theft, complaining of discrimination, and because of his national origin. The court below, the Supreme Court, dismissed the whistleblower claim under Section 75B and also the New York City human rights law claim, finding that there was no subject matter jurisdiction over those two causes of action.
Why isn't the court correct about in light of the voluminous case law on the issue?
On which of that?
That Court of Claims has exclusive jurisdiction on 75B cases.
Well, Your Honor, respectfully, there is no case law that says on 75B that the Court of Claims has exclusive jurisdiction. The relief under 75B, without a doubt, is equitable relief.
Doesn't the statute say that that jurisdiction lies with the Court of Claims?
Not for an Article 75, Section 75B claim. So, Your Honor, the thrust of our argument is that, number one, 75B only provides equitable relief. So the Supreme Court, under the New York State Constitution, has original jurisdiction over equitable claims. That includes, under 75B, reinstatement to employment and back pay. That's not legal relief. It's not monetary damages, as the state keeps trying to blur and blur below. It's equitable relief.
The issue is whether you are suing a state entity, no? I thought if you are suing a state entity, that must be in the Court of Claims.
We do not agree with that, Your Honor.
And what basis is it that you have to not agree with that?
Because the relief available...
I understand equitable relief, Supreme Court has jurisdiction over equitable relief, but that is not the end of the analysis.
I'll move to the second prong is that the jurisdiction of the Supreme Court comes from the Constitution. By amending the Court of Claims Act, the legislature can't remove a constitutional power granted to the Supreme Court. So, in essence, what the state's argument was and what the court below agreed with is that...
Counsel, would you juxtapose that with the reality of sovereign immunity?
Exactly.
Well, sovereign immunity here is not implicated because the only relief sought is equitable relief. So, in other examples, you could bring in Article 7.
So you're saying that so long as the relief that's being requested is equitable in nature, it doesn't matter that you're suing the state, you can do that in Supreme Court?
Yes, because you're not seeking
Really?
monetary damages. That's the whole basis for an Article 78. We've heard about those today, which is based on the writ of mandamus. If you have an Article 78 against the state, you can bring forward a 75B defense seeking reinstatement and back pay. The reason those can be heard in the Supreme Court and they don't have to go to the Court of Claims is because all the relief is equitable. And under the history of the writ of mandamus, going back to England, it wasn't considered to invoke sovereign immunity against the crown. And that is still the case today. So you have to look at not as who's being sued, but what is the relief sought? Is it injunctive relief? Is it equitable relief? Or is it monetary damages, which can only be sought in the Court of Claims?
If we don't accept this argument, what else do you have to go on?
Well, the other argument is simply that this is unique. You can't look at the other types of claims in the Court of Claims Act, because in all those other causes of action, they weren't being litigated into the Supreme Court. The claims couldn't be brought until the state waived its immunity and said, now you can proceed in the Court of Claims. But 75B claims against the state are different and had been brought in the state in the Supreme Court against the state without any objection from the state of New York or the Attorney General's office. And one of those examples is
But the fact that a case went forward without objection doesn't mean that you have a right, as a matter of course, to pursue those same actions on another case.
well, Your Honor,
Perhaps there was a reason on those cases that they chose to allow it to be litigated in state court. Doesn't mean that they have to for every case.
well, that's true, Your Honor, but it is circumstantial evidence that our argument is correct. And the state cites no case saying that if you're only seeking equitable relief against the state, you have to be in the Court of Claims.
Okay, would you like to be heard on another issue?
Yes, I'd also like to be heard on why the New York City human rights law can apply to state employees acting in their personal capacities, sued in their personal capacities. Now, under the Morel...
These men that are complained of individually were acting in their official capacity as employees, were they not? This wasn't a personal circumstance. All of their acts complained of were conducted under the guise of their employment.
Well, number one, we don't agree with that there's no official duty to discriminate or retaliate.
Of course not.
And if you look at Morel, the Court of Claims decision, when it talks about official duties, what they're really talking about is the core agency functions of the state agency. So OTDA is the agency here. They provide housing to low-income families.
Yes, and his supervisors had to supervise him. And if they did so in a discriminatory manner, that is not just personal, that is employment action.
Well, Your Honor, our position is that is actually against the official duty of not discriminating. OTDA, like all state agencies...
Counsel, we're saying the same thing, obviously. But that's not the point. The point is that the behavior of the men complained of was done in their official capacity as his supervisor.
I don't believe we are saying the same thing, Your Honor, because that's...
Well, you can explain it to me on your rebuttal time, okay?
Thank you.
Counsel, you're up. You may proceed.
May it please the court, Blair Greenwald on behalf of the respondents. First, while Ajoku here could file his whistleblower suit in the Court of Claims, he cannot file it here against the state in Supreme Court. The court is correct that the default rule is that the Court of Claims is the exclusive forum to seek monetary relief against the state. And here, regardless of whether it's characterized as equitable or a legal remedy, Ajoku is seeking monetary relief against the state, specifically back pay. He's seeking not only compensation, fees, and costs, but also attendant injunctive relief, which the Court of Appeals has explained in the Sadie case is perfectly appropriate for the Court of Claims to address. In addition, Ajoku here seeks to depart from this default rule and treat the whistleblower claims differently than every other type of claim enumerated in the Court of Claims Act, which is exclusively to be litigated in the Court of Claims. That is in Section 9, Subdivision 13. Permitting this extraordinary departure would cause all kinds of interpretive as well as practical difficulties in litigating. In addition, while the legislative history acknowledges that Supreme Court does have jurisdiction over whistleblower claims brought against non-state entities, the statute makes clear that when it's brought against the state, it needs to be brought in the Court of Claims.
Okay, why don't you address the issue of whether the plaintiff stated claims with respect to national origin discrimination under the state HRL?
Of course, Your Honor. So he failed to state a claim of national origin discrimination against the agency and the deputy commissioner here. Specifically, there's no specific factual allegations that either were aware, much less that they condoned discrimination on the basis of his national origin.
He complained. He complained when a non-Nigerian was elevated who had less experience and a lower score than he did on a promotion. He complained.
Your
and
Honor,
nothing was done.
Your Honor, while he alleges in the complaint that he complained to other employees, there's no allegations that the deputy commissioner was aware of these.
Well, he complained to
He does-
Frazier, he did complain to Frazier, right? About.
He alleges that he did, yes.
Okay, and Frazier's just one rank below Contento, correct?
Yes, although under the statute, his knowledge cannot be imputed to the agency because you need to be a high-level supervisor.
Well, she reviewed the employment review that Frazier did of the plaintiff, correct, of the petitioner?
So I think, in fact, it was Humphreys who made a work evaluation. But the issue here is that the factual allegations say that while he may have complained of certain misconduct, there are no allegations that he reported any discrimination.
Sure he did. He said that his two supervisors said, no, we have enough Nigerians here already.
That's correct.
That is an absolutely racial comment that shows racial animus.
I agree, Your Honor. However, there are no allegations that he reported those comments to Contento or the agency, and his claims are limited to those two.
So he's going to tell them, someone got promoted over me, but not going to tell them that a racial comment was attached to that employment action?
So there are actually two separate issues. So he says that they made those comments.
Didn't the plaintiff report Dudley's discriminatory behavior in writing to Contento?
I'm sorry, Your Honor, I didn't hear the question.
Didn't the plaintiff report Dudley's discriminatory behavior in writing to Contento?
He says that he did with regard to, he calls it discriminatory misconduct with regard to the heavier workload that he received rather than to other employees, but in fact, that was addressed. But he alleges in the complaint that both Dudley as well as the two other consultants were disciplined and suspended. So the agency actually addressed that. He does not say...
And warned him, you're okay now, but as soon as I retire, Dudley's going to be your supervisor.
Respectfully, what he alleges that he reported were retaliatory actions, and those claims are still live. In Supreme Court, he is still pursuing his claims of retaliation and hostile work environment. But the issue here is that he never reported to Contento or the agency that there was a discriminatory animus behind any of these actions, and he needs to report that in order for the agency or Contento to take action. Again, the issues of whether
Does plaintiff agree with your characterization that he did not report the racial animus toward him?
On the face of the complaint, he alleges that he never alleges that he reported those comments to Contento or the agency.
Okay.
For those reasons, we would urge the court to affirm the decision below.
Thank you.
I want to pick up on...
Could you address the national origin discrimination, state claims, and why you think they're viable?
Well, I would primarily rely on our brief. I think it's laid out, but to comment that he complained to mid to high-level employees, Dudley, Contento, Ms. Walters, I believe Johnson, and so that can be imputed to the state. They didn't take any action, so it shows that they went along with the discriminatory
Your
actions.
adversary says it cannot be imputed, that he had to complain directly.
Well, in the brief, we lay out that he complained to mid-level employees, and we cited the cases that show that that's high enough to be imputed to the employer, and they went along with it by not taking any action or to remove him from Dudley and the people that were harassing him, giving him bad evaluations. So we say that on the complaint, enough was pled. If I could just return to the New York City human rights law and why it can apply to state employees in their personal capacities. Now, we were talking about whether it's official duty. That's element number one of the Morrell case that the state says controls here. But if we look at number two, the question is, okay, they were acting in official duty, but was the duty owed individually by the employee to the third party, like Mr. Ojoku, like a tort? The correct analysis is that the city human rights law requires and imposes a personal duty not to discriminate or retaliate against other citizens of New York City. So under Morrell, like the surgeon conducting surgery of a patient, the state wasn't being sued. The doctor owed a duty to not violate the negligence standard to the patient.
A doctor takes a Hippocratic oath to do no harm and to assist anyone who is in a medical situation. I don't think that your average office worker has a similar mandate. But we accept your point and we have your briefs. Thank you. People versus Whitfield. You may proceed.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent appellant William Whitfield. I will be focusing on the excessive sentence argument. First, Mr. Whitfield does not contest the seriousness of this conviction and crime, and these arguments today are not meant to minimize the damage that was done. We are asking the court mainly to run the sentence in this case concurrently to his 2 Kings County sentences, in addition to reducing it to the minimum 10 years. When he was sentenced, Mr. Whitfield was given a prison term that was longer than he had been alive at that point. He was 18 years old when this crime occurred, and his entire criminal history spanned 2 years, his prime adolescence. His actions are not indicative of a lifetime of crime. He's not a hardened criminal or an irredeemable person. He's a teenager who made grave mistakes.
Was it his 4th felony conviction, this one?
I believe it was his 3rd felony conviction, Your Honor.
By the age of what?
18. As I said, he's a teenager who made grave mistakes, but 20 years incarceration during the young adulthood of his life.
He wasn't given 20 years on this case. He had committed separate crimes in Brooklyn. I thought he was sentenced to 11 years on this case.
Yes, he was given 11 years on this case to run consecutively to 2 9-year sentences in Kings County. So we are asking the court to run these sentences concurrently. A decade.
Which basically would equal 2 years for slashing a man's face from the top of his forehead down to the bottom of his face. I mean, really, 2 more years, that's it? For that?
A corrections officer, I believe, too.
Yes.
A decade for Mr. Whitfield, who was only 18 years at the time, is still a severe, weighty punishment. However, by running these sentences consecutively, it would still allow Mr. Whitfield a chance to build a life on his own. If the current sentence is upheld, his earliest possible release date will be in his mid-30s. He'd be re-entering society with no job experience, no experience living independently, few social ties to the outside world.
25 years consecutive, am I right?
Excuse me?
He was facing 25 years to run consecutive.
I'm so sorry.
He was facing 25 years.
Yes.
And got 11.
Yes. 25
I think he got a good deal.
However,
in light of the severe injury to the correction officer.
Yes, there's no doubt
you
that
are
this
asking for a reduction that would basically just give him a slap on the hand for disfiguring and maiming this man.
It was an absolutely serious crime, but a decade behind bars for someone of his age is still a severe punishment, which would absolutely alter his life. And that amount of time.
What remorse has he expressed?
He did address the court at sentencing and apologize for this mistake and the trouble that he has caused. And if there are no further questions, I'll reserve the rest of my time for rebuttal.
Thank you. You may proceed.
Thank you, Your Honors. Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Reva Grace Phillips, and I am here today on behalf of the respondent, the Bronx County District Attorney's Office. Given opposing counsel's argument, I'll focus first on the excessive sentence portion, and then if time allows, go to the other points here. I begin by correcting my opposing counsel. Your Honor was right when he said this is the defendant's 4th felony conviction. This is the defendant's 4th felony conviction. Defendant's first arrest occurred in 2013 when he was just 16. He was convicted in 2016. Just 6 months later, he found himself arrested again. He was arrested when he was 17, then arrested again when he was 18. Then, while at Rikers, facing disposition or pending disposition of those 2 charges, he committed this coordinated, violent, predatory gang assault on a corrections officer that, as Your Honor pointed out, left him disfigured with a scar running across his face. Your Honors, I additionally note that 2 of his prior convictions covered underlying initial charges of attempted murder. Almost every conviction, except for the instant conviction, included allegations that defendant had a loaded and operable firearm. I point to defendants cited in their brief, Roper versus Simmons and Miller versus Alabama, 2 Supreme Court cases where the Supreme Court really wrestled with the concept of emerging social science and evolving morality when it came to culpability of youthful offenders. I find the Supreme Court's words there very pertinent to this defendant in particular. The court there first started by saying, under the age of 18, we're going to create a bright line rule, categorically less culpable under the age of 18. Defendant's instant conduct when he was 18. He's excluded from the analysis on age alone. But he's further excluded by the actual concepts the court is wrestling with. The court expressly premised its rulings in first Roper and then in Miller, citing back to Roper, on this idea that it's very rare that a youthful offender is engaging in repetitive criminal conduct. They said that's rare, so less culpable because of evolutionary and biological reasons, but also because it's rare that these people repeat offend. Here we have a defendant who, as Your Honor remarked, is on his 4th felony conviction. Faced with repeated opportunities to change his life, he did not. Faced with repeated moments where he had to be facing the seriousness of his conduct, he yet again chose to engage in violence. He yet again chose to coordinate an attack with a gang member here to engage in violence on this correctional officer. And as the sentencing court rightly noted, he deserved no more leniency than what he got. He got 1 year over the minimum here. And the court noted it would never have considered concurrent time. The court noted at sentencing that it had felt for at least a year that consecutive sentencing was the only appropriate thing here. Additionally, Your Honors, I note that defendant failed to preserve his claim that his plea was invalid. Defendant's plea was valid. Defendant validly waived his right to appeal. Even if he did not, I've addressed the excessiveness of his sentence. And I end by noting that this court should also not waive this defendant's mandatory fees and surcharges. That amendment is not retroactive. It was passed in August of 2020. As the Court of Appeals found in People v. Guerrero, those mandatory surcharges are not a punishment, so the amelioration exception doesn't apply here. Additionally, none of the 3 enabling subsections apply to defendant. He has provided no proof this would work an unreasonable hardship on him or his family. He's provided no proof that this would work an adverse impact on his reintegration, especially given that he faces substantial time incarcerated where he'll be able to pay off these fees. And finally, Your Honor should not exercise your interest of justice jurisdiction on behalf of this defendant for the same reasons when I mentioned his record and the severity of his conduct here. Unless Your Honors have any questions for me, I rest on my brief.
Thank you.
Thank you.
Your Honors, very briefly, I would just like to address the appeal waiver in this case. The appeal waiver was invalid, first and foremost. The court's explanation of what the appeal waiver would forfeit was incorrect. It misinformed Mr. Whitfield of the rights that he would be giving up. The court said, you're giving up the right to have a higher court review this plea proceeding, which is blatantly incorrect. You can always challenge the voluntariness of the plea. The court also failed to explain to Mr. Whitfield that the right to appeal is different than other rights that are automatically forfeited by pleading guilty. The written waiver, Mr. Whitfield also signed the written waiver before ever hearing the colloquy, and the court made no inquiry if his attorney explained it to him or if he understood the waiver itself. If there are no further questions, I will rest on my brief.
Thank you.
Thank you.
People versus Claudio Reyes. You may proceed.
Good afternoon. Allison Haupt on behalf of Mr. Reyes. This case involves the very specific issue of the 10-year period of PRS that was applied to Mr. Reyes.
You know, I was a little confused when I read your brief, because when I read your brief, I said to myself, gee, this must be a case of statutory rape, because you talked about the age of the offender, you talked about the age of the victim, And, you know, I finished reading it and I said, gee, 10 years for a situation like this of PRS is really extreme. And then I did what I always do and what I know all my colleagues do is I read the other brief. And the other brief contains a description of an entirely different crime. It contains a description of a very brutal, violent, extensively long attack on this 14-year-old girl. And, you know, I was puzzled. I said to myself, gee, does counsel for the defendant think we're not going to read both briefs before we decide this case?
Well, Your Honor, Mr. Reyes was not convicted of any crime, nor were
In
those
a plea negotiation, the defendant virtually never, sometimes it does happen that the defendant takes a plea to the top charge, but virtually never does that happen, and that certainly didn't happen here.
But if I may,
and it didn't happen here because the victim of this crime, according to the people, and maybe they're misrepresenting this, was so traumatized that she didn't want to come to court.
So the district attorney's office put on the record that this complainant had no intention of coming to trial. They admitted on the record that they were never going to get a conviction on these other cases. The only possible conviction that they could have for Mr. Reyes, the only thing that they can prove.
That, I understand that, and they had to do that. They had to be honest about that, and they had to be candid about that. But that really doesn't help to resolve the confusion I was left with when I read your brief.
Well, the reason that we focus on the nature of the actual conviction is because that's what's relevant here.
You excluded.
I was not. I was merely presenting the information that is relevant to the issue at hand. And there are two responses here first. One is that the conviction here was a third-degree rape. That's the only conviction that was here. Those are the only allegations.
So you're saying we can't look at the underlying facts from this complaint to assess your issue raised in your brief, where you want us to reduce this so that he can go back and live amongst this community?
Well, so first, one of the things that's important to acknowledge is that we're only talking about the PRS component. We're not talking about his incarceratory component.
Right. He actually got the minimum on the incarceratory end, right?
And he served significantly longer than that. He served longer than the 1.5 years. But what we're talking about, what I think is at issue here...
Is that because he did something wrong while he was in jail?
No, he just had served more time by the time that they actually entered into this plea and sentence, that he had done more than the 1.5 years at the point at which he was sentenced.
Counsel, you're asking basically for equitable relief, right?
Well, no, what I'm asking for is that...
And I have to say that I concur with my colleague. I feel in many ways that the brief was almost misleading. I was floored when I read the people's brief and read about the kidnapping of this young woman and the forcible intercourse 3 times without a condom, and the fact that she was released from his custody 25 hours later. The brutality of the assaults is something that you just glossed over.
But there are 2 points to that, if I may. One is that none of that was proven. That was not what he was convicted of.
He pled guilty.
Of something less.
He pled guilty.
And he admitted to what he pled guilty to. But the second issue, if I may, is that if we're talking, I think what this court is addressing is the punitive requirement of a sentence. And that, frankly, is really the incarceratory portion. Respondent admits that what PRS is meant to be is it's meant to be rehabilitative. And so we're not talking about punitive, about punishing him, about allegations that were not proven
But we're also
against
talking about, when we're talking about somebody who has been convicted of a sexual crime, where they can live and who they can be exposed to, right? So if this changes, somehow it makes it easier for him to go back into a community with schools nearby, etc.
Well, Well, I think it's also important to look at the data about, I think it's up to 96% of cases involving sexual assaults involve first-time felony offenders. So if you actually look at the data, people like Mr. Reyes are not likely to recidivate.
If this is how he starts on sexual crimes, pulling a child into an apartment, into his grandmother's apartment at knife point, punching her in the face, raping her both vaginally and anally, and keeping her there for 25 hours so he could rape her repeatedly?
But frankly, Your Honor, those are appalling details, but they're not what he was convicted of. He has received sex offender treatment. He has accepted responsibility for his crimes, despite respondents' claims to the contrary. What we're talking about is how can we reintegrate him properly into society? And the system of PRS that exists right now is not a rehabilitative focus. It's not what it accomplishes. And what I believe this court is talking about is punitive sentencing. He received a punitive sentence. He served that sentence. What this is meant to address is reintegration, and 10 years. He was 21 years old at the time. I'm not saying that what his behavior was appropriate, but when we talk about maturity, when we talk about growth, he's going to be 36 years old at the time that all of this is completed. There are certain elements of his own nature that will allow him to grow and mature. We see that with brain function and understanding impulse control and consequences. But this PRS is supposed to focus on rehabilitation, and the system that it imposes right now does not do that. Other things are in effect to make sure that Mr. Reyes moves forward with his life. There are certainly another option. I'm not saying that he shouldn't have any PRS, but to put him on this for a full decade for what he was actually convicted of, I argue is excessive.
You realize that a SORA hearing, the discussion isn't limited to just the penal law section I pled guilty to. The court listens to and considers the factual circumstances underlying the complaint. So your desire to have us just narrowly focus on the penal law section that he was able to plead to because we have a victim who doesn't want to be re-traumatized in a courtroom doesn't change the underlying facts of this case. But you have time on rebuttal. Counsel will hear from you. You may proceed.
May it please the court, Shane Magnetti for the Office of Darcel Clark. As your honors already understand, when considering whether
when this victim said she's never going to appear in court, was that because she changed her mind about what happened to her?
No, Your Honor. This victim preferred not to come in and be re-traumatized by experiencing the rape via trial because there was a 4-year delay between the rape and between the people being ready for trial because this defendant was able to evade apprehension by using an alias. So 4 years later, when she had her life together and she was going to school and she was working, she did not want to revisit this by going to trial. And that is why he was able to obtain this windfall plea agreement to the minimum term of incarceration and the maximum term of post-release supervision. Now, my adversary's misgivings about the wisdom or efficacy of post-release supervision or of SARA overlook the depravity of his conduct here, and they miss the point of those two laws to begin with.
Well, she's also arguing that, he's a certain age, he'll be 36 by the time this is over, and he can't find housing. Are these extraordinary circumstances for which we should modify any sentence?
Absolutely not, Your Honor. The defendant was 21 years old when he raped a 15-year-old. He was a full-grown man. And unless Your Honors have any other questions, I will rest on my brief.
Thank you. Counsel, you have time.
Thank you. I would just note that the standard is not one of extraordinary circumstances. This court is tasked with the obligation.
You keep talking about how old he's going to be when he finished. You didn't tell us that he was hiding out for 4 years with an alias, or a couple of years with an alias. Maybe he would have been finished sooner had he come forward.
Your Honor, it was not an alias. His middle name is Manuel, and that's what he goes by. There was no alias here. That's a misrepresentation of the record. I think.
Was he evading prosecution? Was he evading apprehension?
Not that I'm aware from the record, it's just they didn't, did a DNA swab that revealed him and they came upon him. I'm not aware from the record that he was evading information, and he certainly wasn't using an alias. He was just known by his middle name, which was what the complainant provided to the police. I think also, there is some mention of the reasons why the complainant didn't want to testify or come to trial at all. I think there is some expanding or expounding upon. The record isn't clear. They do make it very clear she is not coming in. She does talk about how that's later in time and she's moved on in her life. I think that's a little bit of an expansion that respondent provided. And again, I would just argue, if you think about the purpose of PRS, I don't think that it's meeting its rehabilitative purpose here, and there's certainly a different alternative besides the maximum 10 years. Thank you.
Thank you. Thank you.